Leonora is going to introduce a bit what the GLCA is, to come here, to spend some time with us, to exchange on matters and to discuss customs and international trade. I'll introduce the program in a bit, but I'll hand over the mic to Leonor.
Good morning, ladies and gentlemen. My name is Leonor Cordovil. I'm a Brazilian lawyer, so came after 15 hours flying to here. It's a pleasure to be here in this wonderful country and represent our network, GLCA. GLCA is a group of lawyers. We are currently 21 lawyers from several jurisdictions around the globe. Normally, we are represented by one lawyer per jurisdiction. And we see each other virtually on internet once a month, and we meet in person once a year. So this year, Thomas kindly invited us to come here to see how wonderful and impressive this country is. And we are very glad to be here. And if you want to know more about us, please visit and follow our LinkedIn, our webpage, or please send us an email, and we'll be very happy to clarify and to say what we do. So on behalf of GLCA, I would like to thank you for coming in person today, and for the ones following us on internet. And please, and also to say a big thank you to Thomas and his firm for this wonderful conference, and for being the best host and best external lawyer of the globe. We rotate, in fact, it's 1 year each country. So please enjoy the day with us. Thank you.
Thanks very much, Leonor. While I'm struggling a bit with the wires here, again, thank you again on behalf of our firm, everybody involved in the organization. Thank you for that. We have quite an extensive program today. We will be hearing about EU customs reform momentarily. I'll invite the speakers in a bit up to the podium. And then we'll also hear from Professor Atiya Hussein, who's going to be joining us a bit later on customs compliance in free zones. Very important topic in the UAE. We will then take a lunch break. We'll invite all of yourselves for lunch. To then look at a very hot topic, which is sanctions. Obviously, this is the UAE is fairly neutral territory from a sanctions point of view, but we find ourselves a bit in the middle of a number of big powers sanctioning each other. And we will have David speaking from the Commercial Bank International, which is a UAE bank, talking about how banks deal with these sanctions, specifically how they sometimes not deal with them, or how the type of questions and situations they are faced with. David is a very good speaker, and heads up, has no filter, so he's a great guy to ask questions. He'll be speaking also in his personal name rather than in the name of his employer. We will have, let's call it the Battle of the Beasts afterwards. That's not a reference to the speakers, but rather to the powers that are going to be talking. We're going to hear from advisors from both Russia, the US, and the EU around what is the current state of play, what is permissible, what is not, sanctions, counter sanctions. That's going to be quite an exciting panel. And we will close off the day with two presentations. One is of a dear client of ours that is active with a lot of governments in not just in the region, but also in Africa, helping them to develop their organization, their IT infrastructure, and helping the government side with customs compliance. To then close off with another company, which is a UAE company that has developed a track and trace program to determine origin of medication. So when we purchase medication in UAE pharmacies, to ensure that we know where that medication essentially comes from. So without further ado, I'd like to invite Christian, Lars, Fausto, and Arno on the stage, and they are going to be moderated by Agnieszka. So please come to the stage if you'd like. Christian works with KMLZ in Germany, German powerhouse in the field of indirect taxation and customs. Lars works at Glaser Law in Austria, Fausto at GOP in Italy, Arnaud at DS Avocat in France, and we've got Agnieszka working at MDDP in Poland. I'm going to leave this mic for you, and I'm going to give this mic to the different speakers.
Thank you very much for this kind introduction, Thomas. Good morning, everyone. Thank you for joining us today. We have a really exciting topic of EU customs reform. Our agenda for next an hour and a half is to discuss a new EU Customs Authority and Data Hub, trust and check status, indirect representation, e-commerce, and customs valuation. That's in a nutshell. And I'm Agnieszka Kisielewska. I'm based in Warsaw, Poland, working as a tax advisor and customs advisor with MDDP, leading tax advisory firm. With us, we have excellent speakers today, starting with Christian Salder of KMLZ. Christian comes from Munich, Germany, and he is dealing with customs and tax matters. And then we have Lars Glasser. Lars comes from Vienna, Austria. Lars is a founder of Glasser Law Tax Boutique firm, and Lars is also dealing with customs and tax issues, mostly in Austria. So then we have Fausto Capello of Gianni Origlioni. Fausto is based in Milan, Italy, and Fausto is also dealing with VAT, customs, and he will be introducing the topic of e-commerce connected with VAT and customs as well. So we have Arnaud Fendler of DS Avocats. Arnaud is based in Paris, France, and Arnaud will introduce the topic of customs evaluation. Christian will be introducing the topic of EU Customs Data Hub, and Lars of trust and checked status mostly. So we can go to the quick introduction of the reform itself, and the plans of the reform are really ambitious. The Commission says it's the most ambitious and comprehensive reform of the customs union since its birth in 1968. So what kind of union we should expect after such a declaration? First of all, efficient. We need a lot of simplification and modernization of customs procedures. And also EU came to the conclusion that we need more sources to defend the financial interest of the EU, but also security, safety, health, economic and environmental issues, and our EU values. So that's the foundation. And the other part is to stay future-proof and agile, to be prepared for the future, be more flexible, and be more prepared for changes. Why is that the foundation? We think that after facing the polycrisis of the pandemic, of the war at the gates of the EU, and of the complicated environmental issues, the EU Commission wanted to address all of it and build something more future-proof for our kids and grandkids. Speaking about the timeline, the timeline provides that in 4 years we will have the first access to the EU Customs Data Hub, the new idea Christian will be describing to us. And can we be skeptical about this timeline to seeing in 4 years the hub? We can discuss about that probably at the end of our presentation, why we can or cannot expect that in 4 years. In 8 years, we will be facing probably the obligatory access for like all business, excuse me, not obligatory access for all business. The first part was for e-commerce, and the second is for all business. And in 14 years, we have the obligatory access for everyone. So that's the outline of the timeline of the reform. So we will now go to the presentation part. And speaking about housekeeping rules, we will take all your questions after our presentation. If the time will allow us, there will be all questions addressed, but if we have like many questions, we will try to discuss some and address other individually. So please feel free to like address your questions in our Zoom platform. So I'm giving the floor to Christian. Thank you very much.
Thank you very much, Agnieszka. And good morning, everyone. Well, EU Customs Data Hub is the first topic that I'm going to present to you. And I thought it would be a good idea to just summarize where we stand currently, because EU Data Hub does not seem to be that modern and that type of a future topic that could be timed for the next 15 years or so. Actually, you would expect maybe that we even have such a data hub, but that is not the case. Maybe you know that the European Union forms a customs union, and this is meant to be a legal framework with unified provisions, regulations that apply throughout the EU, but there is a lack in administrative and technical implementation so far. That means that, for example, data is collected not on an EU level, but on a national level. We have in our member states different IT systems. Every member state runs its own system, its own tool, creates that tool, develops it. And so for economic operators, it is difficult to use only one software to file the customs declarations. So for example, if you ship as a German company goods from France, there is, of course, some interface to the French system right now in place, but that interface does not, again, communicate with other interfaces of other member states. So there are huge technical hurdles, and normally, as long as you're not also established in those other member states, you need to engage a service provider or get your separate software for those member states. And of course, needless to say, on this basis, there is a lack of intelligence or exploring the data, analyzing the data, and what's going on in businesses, what's happening when goods are crossing the border. So to say, there is a lack in risk analysis. And this, of course, gives a good floor for the EU Commission to start an initiative on unifying the technical aspects of EU customs law by starting a EU customs data hub. And this data hub is meant to be meant to build up EU-wide databases that also allows an EU-wide analysis of the data and a sharing of the data, not only with customs authorities, but also with any law enforcement department and other players in the field. But I will come back to this later on. So what is the idea of that data hub? The idea is that the various actors in the market have to store the data in that data hub. They have to pay in. This is also illustrated on the left-hand side, that the traders in yellow have to pay in the data into that hub. And the benefit out of the hub and the capabilities to use the data is given to the authorities. On the left-hand side, in blue, the law enforcement authorities. On the right-hand side, any market surveillance authorities that are also interested in having that information. So you can see that, of course, we are talking about an EU customs data hub, but in the end, the data that is collected in that hub is far more fruitful for others than only customs. And the idea is that the data is not only collected and analyzed for customs purposes, as I said, but also to understand business and business activities and supply chain itself. We are talking nowadays about disrupted supply chains, so the authorities think it is a good idea to also understand what happens with the supply chains, if there's anything that can be done to facilitate. And needless to say, of course, there are technical means to do that analysis way better than in the last decade, talking about real-time analysis, machine learning, AI, that are tools that certainly can help to analyze that data on an EU level basis, as well as we know that from a company level. So what's the benefit for businesses? There is only one tool that you have to use for the whole business throughout the EU. And you can use the simplified customs procedures that can be offered through that data hub. In some situations, the EU Commission is thinking about the option to reuse data that has already been stored in the data hub for following imports. And of course, that's what the EU Commission always says when they want to justify a reform. They say that there will be a cut in costs for businesses of around 2.7 billion a year. Don't ask me where this number comes from. This is always more or less a political thing to argue that, of course, there will be a cost-cutting effect. But the data in that respect is also uncertain and driven politically. And in particular, there will be another measure, or at least there is a measure proposed in the initiative that is the trust and check traders that will, in addition, benefit from other facilitations, especially on the imports, for example, without any intervention by customs authorities or other administrative burdens. What's the benefit for the authorities? Of course, they get a huge data mine that they can exploit, explore, analyze. And given the technical options that we have nowadays, this can be a huge step forward for them to understand what's going on at the borders. And as I already mentioned, not only for customs, but also for Olaf, Europol, Frontex, any administration, any authority that is dealing with the transactions and activities right at the border. They will have the chance to understand the business concept of each and every company on an individual basis. As I said, you can, of course, do some data mining, process mining, and understand what an individual economic operator is doing. And that, of course, also is a question of efficiency for them to tackle tax fraud, as well as any circumvention in terms of prohibitions and restrictions to import, export goods. So in the end, you can say that actually the authorities will be enabled to step in and intervene on the supply chain whenever it makes sense to them at any time, because they have all the information they need, so they can intervene right at the loading of the goods outside the EU or somewhere else at the border, wherever they think that it is helpful. And of course, this data hub, and that is my second point that I want to introduce to you, is that the EU Commission is proposing to set up a EU customs authority, which is actually not the case at the moment. Of course, there are offices dealing with questions of customs within the EU Commission. However, they are not involved in the day-to-day business and in an overall analysis of the data and information that they have. Because remember, the data that is collected right now is collected by the individual member state. And of course, there is a link with a sharing tool, but our experience of the past show that that tool is only as good as the tool is fed by the member states with information. So we have the experience that many member states lag behind with giving information to centralized databases. And so it's not a surprise that, for example, Italian or Greek information is passed on to the EU with a delay of 6 or 12 months. And sometimes there is also a lack in information, so there is no comprehensive data sharing so far. And that would be, of course, different if you have a data hub and a customs authority that works on an EU level, as the concept says, as a decentralized agency, which is, I think, especially also a political aspect in order to not paralyze the EU member states that are afraid that they could lose power if there is a centralized authority. But in the end, this will be the way forward and must be the way forward in order to strengthen the EU customs union. What will be the tasks of that authority? There will be, of course, the administration of the data hub. There will be a risk assessment, and that is new and important, a coordination of crisis management. I think that is also a lesson that has been learned by or during the pandemic in the last couple of years, that the EU Commission understood that there are so many players that are acting in different ways, that it actually is a problem to do reasonable crisis management. So in the following two slides, I just put together the aspects of a risk assessment. Needless to say that the reform also promises the national member states that they get the information as well that is collected on an EU level, and they will continue or may be able to continue to do their own national risk analysis. Of course, what also is important for the coordinating function of that customs authority, as already stressed, crisis management, meaning that, of course, the information collected in that data hub is also made available for market surveillance measures, law enforcement, and so on. That's it for the moment. I'd like to hand over to Lars then, presenting the trust and check traders.
Well, good morning, everybody here, and good morning, afternoon, whoever is online also here. Thank you very much. I'm going to talk about two issues out of the customs reform. So one that Christian already mentioned shortly, the trust and check traders, and then one of like the most controversial topics, the indirect representation. So starting with the trust and check traders. So what is this actually going to be? So the aim of the European Commission is to aim at a fundamental shift of the relationship between customs authorities and economic operators. So as we know today, at least everybody connected somewhat to the European Union, we have the concept of the so-called authorized economic operator. This is specific economic operators that fulfill certain requirements of trustworthiness and transparency, and they're two different types of for simplifications and for safety and security. So, and if they fulfill these requirements, they receive some additional benefits. There are some simplifications. So some requirements for imports are taken as granted, as fulfilled already. So if they fulfill the status, they have an easier life, let's say like this, when they import duties. And this concept of the authorized economic operator, this shall be enhanced. This shall be taken to a next level. So from the outset, the authorized economic operator shall continue to exist, but there shall be an enhanced version of this going forward, which shall be the trust and check traders. And the overall guiding principle of this is transparency, and connecting to what Christian just said, basically to fill the EU data hub. So we can see it like this. So this is what Christian already mentioned. There's the traders in general and the trust and check traders in particular, they will contribute data to this data hub at the end. So just quickly coming to the requirements. So what are they expected to fulfill here? So first we have the standard authorized economic operator requirements. So this is the clean legal record. So here it is slightly more specified over the last 3 years. There must be no breach of conduct in any relevant customs or relevant part of law. A high level of control of operations and supply chain. We'll come to this later again. And financial solvency. So they should be able to fulfill their customs obligations. And this is now the crucial part. Then there are some additional requirements. So first of all, the trust and check trader should fulfill all the requirements that the two types of the authorized economic operators fulfill. And then this is now the crucial part. They should operate an electronic system that makes available real-time data on the movement of their consignments and their compliance. So basically, what they should do is not just having a high level of control of their supply chain and having the information over the supply chain, but the aim is to have every piece of information in real time over the supply chain. So not just a customs declaration when they import and then everything is reviewed, but basically to include the data in the data hub at every moment something changes, where the goods move, what may have happened to the goods. So this is what they fill into this data hub. And then they have to have a conduct of regular customs operations in the course of the last 3 business years. This is the other requirement. So what do they get out of this? So the first major benefit should be, while currently any economic operators importing goods into the European Union, they may typically have to deal with the customs authority of the state, of the member state where they import something. So going forward, the trust and check trader, they should only deal with the customs authority where they are established. So this is a one-stop shop system for customs. So this is a test run, more or less, that will be evaluated, and then maybe the new normal for every trader as of 2035. The timeline may be subject to discussion. We can talk about this later also with the audience. But this is one of the main benefits there. You have your contacts in the country where you're established, regardless where the goods are imported into the European Union. Then the reduction to a minimum of paperwork and formalities. So obviously this is some kind of, sounds like you have to do less, while at the same time you have to provide real-time data to the data hub. So what this basically should refer to is there is no customs declaration at normal. When you come to the border where you filed customs declaration, this is reviewed, because anyways you include real-time data all the time during the consignment. However, there may be an exception. Of course, you may have some pre-loading and pre-arrival information. So, but this is the standard there. Then one of the major benefits here, all this transparency should allow at the end for green lanes. So it should be possible that goods are simply driven over the border or flown over the border whatsoever, and there is no customs intervention at all. So this should be the standard. However, there may be exceptions, of course, if there are some other legal requirements where something must be reviewed, or if a customs intervention is announced, or if the data provides for some risk over the supply chain, that something must be reviewed. So obviously the customs authorities always have the right to intervene somehow, but the aim should be for everybody to simplify things. If you provide everything into the data hub on a real-time basis, then the goods are gone through, and at the end there's even a self-release by the trust and check trader. So there's no formal act of the customs authorities, but the trust and check trader can self-release the goods if there is no previous intervention. So self-monitoring and self-release. And the other part is on the payment of customs duties. If there is all this data in the hub and there is a certain expectations of which goods are going to be imported when, then there is an option for periodical and therefore also deferred payments. So it's not just you cross the border and then you pay the customs duty. It's rather that you assess yourself and you make periodic payments that may even be deferred there. So this is the benefits and the simplifications for the businesses. Obviously, there are also some benefits for the customs authority. So first of all, they have a full supply chain overview. So they have the ability with the data hub to have also, the aim is to also have artificial intelligence to somehow review on a risk analyzed basis if there is some risk hidden at the end. They can review the quality and coherence and accuracy of the received information, and therefore the trustworthiness of the trust and check trader. So if they consider something missing or whatsoever, they can evaluate the trust and check trader as such, and at the end, they may even revoke or suspend the trust and check status. So they have full transparency, and this new relationship, you can say, should be a relationship of trust, but of course this trust can also be checked by the customs authority, and the status suspended if necessary. So this is just an overview of the new trust and check trader. So we can also discuss how likely this is to be applied, or how this is seen in practice by many people. So if logistics providers consider themselves in a position to provide all this information. So I think now we have commission guidance about 260 pages on the authorized economic operator status of what are the requirements and what are the benefits and so on. So I think it will be very interesting to see something similar on the trust and check status. So what are the details then that must be fulfilled there? And this is also somehow linked to I would consider one of the most controversial topics of the EU customs reform, indirect representation. So just quickly, everybody is aware of customs representatives. So you have direct representatives that basically act in the name and on behalf of their importer, more or less. So they assist them more or less. But you also have indirect representatives where the huge practical issues, typically they act in their own name, but on behalf of somebody else, but acting in their own name also triggers potential liability for customs duties. So typically logistics providers, they try to avoid indirect representation as much as possible in order to also avoid liabilities if there's a liability. So what is now new about the indirect representation? Interestingly, it's always interesting when some legislative body or whatsoever, so here it's the commission introducing this proposal, they talk about the clarification of responsibility. So clarification somehow sounds like it has always been like this, so we just want to clarify something, but at the end there is a huge change in how indirect representation should be perceived, because the indirect representative themselves, they should be considered as the importer of goods or the exporter of goods. So this means they're not just severely liable for customs debt, but also for any other obligation that the importer may have. And going forward, if customs not only deals with customs duties, but should also review any other obligation provided by some other part of legislation, then there is a liability where the question is how can they fulfill it at all? So this is subject to huge discussions, and also in the review of the proposal, there were many comments on this, because how should an indirect representative figure out whether he as the importer fulfills a carbon border adjustment mechanism duty? So what information must be provided there? So there's product quality conformity with EU standards, so deforestation or forced labor. So it's one thing to know about what is the good, what is the value of the good, what is the customs duty, and I may be liable for this, but do I know whether forced labor was involved in producing the good at the very beginning of the supply chain? So this is something where, well, people in practice say this is not possible at all. So they can impossibly be indirect representative because they simply don't know all of this. And maybe Fausto will also come back to this with the deemed importer. And then connecting it to what I presented before, if trust and check traders have the status of the trust and check trader, they can only represent with using this status if they act as an indirect representative. So the question is, okay, how first you have to fulfill all these requirements, provide real-time data and everything. And then at the same time, you may not even have all this information and shall become liable. So all these benefits you may not even be able to use, because in practice, you may not be able to act as an indirect representative because you simply don't have the information. So this is just how should indirect representatives possibly comply with these requirements. So we discussed it before, what our experience so far is from what people in practice say. So it would also be interesting if somebody in the audience already has some ideas about some clients try to go to the European Commission to make submissions to change this somehow. It's unclear whether there will be some clarifications in guidance, but if it's written in the law at the end, it's a question what this soft law should bring at the end. So this is a huge issue there, and it remains to be seen how this will be dealt with, not in practice, but maybe going forward in the legislative process if there are some amendments to be expected here. So this is my part, and then I would like to hand over to Fausto, who's going to talk about e-commerce and the future of the 150 duty rate.
Thank you. Welcome to everybody. In my presentation today, I'm going to go through some key pillars of the reform that is incoming in the European Union. The reform initiative is based on 3 different proposals, legislative proposals, 2 regulations, and 1 directive. The regulation in the European Union is immediately applicable. The directive needs an implementing framework published by the EU countries. Today, we focus on some of the key pillars, and specifically the distance sales of goods to be imported in the European Union, the removal of the relief, duty relief for goods having a negligible value, the duty bucketing system, and the alignment on the VAT rules needed for the implementation of the reform. The rationale of the custom reform is based on the studies of the European Union. At the moment, according to the statistics, e-commerce represents more than twice the number of the traditional value in terms of transactions. And e-commerce accounts only 0.5% of the value. We can consider that the number of declarations submitted in the European Union in 2022 accounted for 1 1.1 billion declaration in relation to super reduced custom declaration. So for goods having a value less than 150 euros. The value declared is in general about 3,000 billion for traditional traders and about 12 billion for super reduced custom declaration. This put under pressure custom authorities in the European Union, but the situation risked to put under pressure also the revenues of the European Union and the member states because of undervaluation and splitting of consignment in order to benefit from the exemption. At the moment, according to statistics, custom duties accounts for about 11% of the EU budget. And for member states, the revenues for VAT accounts about 26%. The removal of the duty relief related to 150 euros for goods having negligible value is strictly related to the success of the elimination of the VAT exemption related to goods having a value under 22 euros that was removed in 2021. Moving on, the first pillar of the reform and the figure of the deemed importer that is strictly related to the general figure of the importer, we could say that usually in the European Union, the importer is the person having the power to bring the goods into the European Union. The deemed importer is a person involved in the distance sales, not necessarily established in the European Union, importing the goods from third countries, and the person that is authorized to use the import one-stop shop scheme of the European Union. These show the interaction with the VAT rules, the rules that was introduced and implemented in 2021. For VAT rules, the figure of deemed importer is a key figure that is related to the importation of the goods and products subject to VAT, at the moment custom duties, in consignment having an intrinsic value not exceeding 150 euro. What I before mentioned is that the reform will lead to the removal and the alignment of some rule in the VAT field and the alignment of the custom rule with the VAT framework. In fact, one of the key reforms is the removal, also in the VAT fields, of the threshold of 150 euro value for have the opportunity to access and use the one-stop shop scheme. The deemed importer needs to be established in the European Union because in the European Union, the importer, as well the exporter, needs to be established. But according to the reform, also not established deemed importer, let me say, e-commerce platform, could have the opportunity to access to the simplifications, appointing an indirect representative established in the European Union. As mentioned before by my colleague, the indirect representative will be liable for fiscal issues, essentially custom duties and VAT, with a joint and several liability with the deemed importer, but also in relation to non-fiscal measures. For example, carbon border adjustment mechanism, forced labor, and so on. The indirect representative, together with the deemed importer, have the obligation to inform the custom authorities for what is needed to custom clear the goods, related legislative measures, and so on. According to the reform, the payment becomes a crucial moment for declaration, because the information need to be submitted to the custom authorities when the payment is accepted, and in any case, before the release of the goods. In relation to the release of the goods, the reform seems to introduce a big change. This considering that the reform seems to introduce a presumption for which the goods are released in free practice in the European Union when they have not been selected for any control within a reasonable period of time after the arrival in the EU custom territory. This is a sensitive matter because of the information, the timing, and the risk the good entering the European Union without the necessary controls. I mentioned before the joint and severally liability of the deemed importer together with the custom representative, but another aspect of the liability of the deemed importers is relevant in the reform, and specifically the liability for the information provided to the custom authority. It's clear in the VAT field and the judgment of the European Court of Justice that the person involved in frauds could be liable if they know or reasonably should have known something about the fraud, and they need to check and collect information in relation to the general situation. What is happening with the custom reform is to introduce the same rule in the custom field, extending the principle elaborated also by the European Court of Justice. Another simplification related to the reform concerns the entry of the information in the accounts of the platform, because the platform has the opportunity to make a single entry for all goods released during the month, by the end of the following month, with a breakdown of the different amount for each single consignment of goods. Finally, the deemed importer has the duty to prove the exit of the goods and invalidate the information if the goods are returned to the supplier outside the European Union after the custom declaration of the goods. This is a sensitive issue because we see that this implies the cooperation of the supplier and the person involved in the supply chain. Moving on, the second pillar of the reform related to e-commerce. The reform implies the removal of the duty life threshold for the goods having a negligible value. Negligible value means the goods having an intrinsic value not exceeding 150 euro. The intrinsic value is the value of the goods without considering expenses for transport and insurance. In the European Union, we mentioned before that was a success of the removal of the threshold of 22 euros in the VAT field. This amendment to the VAT legislation was approved and entered in force in 2021. And in 2021 was removed the first part of the exemption. At the moment, VAT is applied also to transactions having an intrinsic value under 22 euros. And at the moment, and until the 1st of March to 2028, the exemption for custom duty will be applied also to goods having an intrinsic value until 150 euros. Starting from the 1st of March 2028 is planned the removal of this exemption. So each single transaction will be taxed for custom duty and VAT purposes. There is an exclusion. The exclusion concerns alcoholic products, perfumes and toilet waters, tobacco and tobacco products. In general, the goods that are relevant for the harmonized legislation for the application of the excise duties. Looking at the third pillar of the reform, the duty bucketing system, we need to consider the general rule for the application of the custom duties in the European Union, and specifically the common custom tariff and the combined nomenclature based on the harmonized system. In the European Union, the reform is planning to modify the rules related to the common custom tariff with the introduction of a new chapter dedicated to the simplified tariff treatment of distance sales. In practice, what will happen is to identify some bucket of goods, establishing a duty rate, ad valorem duty rate, and this duty rate is based on the tariff classification on the goods. In principle, goods that at the moment benefits from the zero duty rate will continue to benefit from the same exclusion. But it could happen that some goods and the technicalities related to the bucketing system lead to an increase of the custom duty applicable to the goods. The simplification is relevant, but is not total, because it's still needed to indicate at least 6 digits of the code provided by the harmonized system and implemented in the combined nomenclature of the European Union. A simplification is introduced for non-preferential origin, because the proof of the non-preferential origin will not be required by the custom authorities. People benefit from the simplified tariff treatment for distance sales, may not benefit from the preferential tariff measures, so the measures that are usually provided by the agreement signed by the European Union with third countries, or preferential tariff applicable unilaterally by the European Union. Another element to be considered is related to the value of the goods to be declared, because with the simplified tariff treatment, it is necessary to consider in the custom value the cost of the transfer of the goods until the external border of the European Union, that is normal in the custom field, but also the cost on the transport for the transfer of the goods inside the territory of the European Union. That is typically relevant for the value to be declared for VAT purposes, and essentially the statistic value that needs to be introduced in the custom declaration. Also in this case, there are some products that are excluded from the simplified tariff treatment. And as mentioned before, for the duty relief threshold, the harmonized excise duties, or better, the goods that are usually subject to the harmonized excise duties, the goods that are subject to trade measures of the European Union, anti-dumping, anti-subsidies, safeguards measures, and in general, some goods specifically identified on the base of the chapter of the combined nomenclature: iron and steel, complete industrial plant, and specific goods, for example, goods to be delivered to vessels and aircrafts. The last part and the last pillar of the reform is the alignment of the VAT rules. The alignment of the VAT rules is not part of the custom reform, but this alignment is able to support the custom reform and maybe to speed up the success of the custom reform. The implementation of the custom reform in 2028, it's expected not to be fast, smoothly, without problems. There are many open issues at the moment. First of all, I mentioned before that the customer representative, indirect representative, is jointly and severally liable with the importer. And one question could be if the deemed importers should independently assess the products' related risks, compliance need with the EU rules. And probably the replies should be yes, based on the present proposal for the reform. But the deemed importer and the indirect customer representative could be also exposed to the liability for false statement and unintentional errors made by producers or intermediaries. We mentioned before that the deemed importer needs to communicate to the custom authorities the information relevant for the custom clearance of the goods. But the deemed importer, together with the indirect representative, could be in a position in which is not able to obtain the relevant information for the supplier outside the European Union. I mentioned before that the deemed importer needs to invalidate the information communicated to the custom authority at the moment of the introduction of the goods in the European Union, and to prove the re-export if the goods are returned to the suppliers outside the European Union. In this case, the deemed importer needs the cooperation of the intermediaries and the suppliers established outside the European Union. Considering potential open issues related to the simplified mechanism system, the bucketing system, I mentioned before that it's still necessary to communicate the first 6 digits of the tariff code. But in the European Union, there are some measures that are not related to the first 6 digits. And above all, for import, is necessary to consider the measures related to the 18th or the 10th digits. So the open issue is who is liable for the application of these measures in case of simplified system. The importer or other person acting in relation to the transaction. My colleague Lars mentioned before the relevance of the legislation not related to fiscal measures of the European Union, CBAM, deforestation, forced labor. This legislation should be applied by the deemed importer or the indirect custom representative according to the present structure of the reform. In relation to the removal of the duty relief of related to goods having a value under 150, there is an open discussion with different views, because according to some stakeholders, the removal should increase the external trade, the chance for small and medium enterprises to trade with third countries. The benefit should be the ability for the European custom authorities to check and to decrease the burden of activities in relation to the import. For other stakeholders, the impact should be practically null. The removal of the duty relief for goods related to negligible value opens another issue, because the trade facilitation agreements contains specific rules for which member states shall provide, to the extent possible, for a de minimis shipment value or the dutiable amount for which custom duties and taxes will not be collected. This situation is not applicable to taxes like VAT and excise duties. So when the European Union implemented in 2001 the removal of the threshold of 2022 euros, this rule wasn't a matter because there was an exclusion. For custom duties, the exclusion and the removal of this threshold opens a completely different scenario. The last point related to the removal of the 150 duty relief opens another situation that is sensitive. And the question could be, could the removal of this duty relief encourage non-EU countries to remove their exemption? We know that at the moment, the United States, Australia, and other countries have similar exemption. So if the EU removes the exemption, also other countries could change their policy. The last open issue that I would like to mention is related to the non-tariff measures and specifically trade measure related to anti-dumping duties and anti-subsidy duties. What happened when the deemed importer shipped the goods inside the European Union, introducing them, let me say, in a custom warehouse, and later to declare the goods for free circulation and consumption when these measures entered in force. The duty rate could change a lot. Sometimes anti-dumping duties lead to ad valorem anti-dumping duties 20, 30, 40%. So it could be a matter that should be considered in the contract with suppliers with an highly attention. I think that this concludes my presentation. I would like to thank you for your attention, and I give the floor to my colleague Arnaud.
Thank you, Fausto, and good morning to everyone. I'm very happy to be here with you. My name is Arnaud, and I practice customs law in France. And aside of my practice, I'm also active in the works of the International Chamber of Commerce at World Customs Organization on customs valuation. So I wanted to conclude this panel to talk about customs valuation a little bit in the context of the reform that was just described by my three friends here. So customs valuation is the tax basis for duty and taxes at importation. It's one of the three elements of what we call the customs passport. So classification, HS code, origin, and valuation. Valuation is the only elements of the three that is not harmonized in the EU so far. In the EU, we have harmonization with tariff. We have the binding tariff information that you may know. We have binding origin information, but we don't have any binding valuation information. So at this stage, any subject specific to valuation is, of course, dealt with at EU level, but you still have a lot of national specifications based on the fact that it's not fully harmonized. The UCC, the Union Customs Code, with the regulation that is being reformed in the next few years, provides a common framework that is implemented in very different ways. So we have with this customs reform a unique momentum, hopefully, to try to come over certain discrepancies that we can see in the EU and make sure that valuation is more and more harmonized and treated in a more harmonized way in the EU. So the primary basis for customs valuation, as you may know, is transaction value. This is the main method. And in EU, as in any other country, we have, for transaction value purpose, two mechanisms for individualized decision. We have the provisional value authorization. This is Article 166 of the UCC. And this is a situation where certain elements of the customs value are not known at the time of import. Then you lodge a provisional declaration, and then you're going to amend at the time you know the unknown elements declared in the authorization. Then you've got Article 73 of the UCC, which is the simplification process. So you are allowed sometimes, subject to authorization, to declare in a very specific way certain elements of the value that you don't know at the time of import. And we use this mechanism a lot for royalties, research and development costs, and as well as transfer pricing adjustment. And we have something that is between a binding evaluation information and something that it's difficult to consider is Article 26 Article 26 of the Union Customs Code provides for that certain authorization can be extended to EU level beyond national borders when certain conditions are met, and this applies to customs valuation. So we have a kind of a EU-wide individualist decision mechanism that it doesn't bear its own name, and we're going to see how the reform is going to improve this system with the binding valuation information. The example that I would like to take to like complement my speech is transfer pricing adjustment. Transfer pricing adjustments are a big issue in the EU, as they are in any other country in the world. We have an estimate of about 65% of importation made in the EU that are based on a transfer price. And over the last 3 years, our estimate is about half of this transfer price are subject to an adjustment because of various reasons: inflation costs, transport cost inflation in 2021 and 2022. So about 30% of the customs values declared in Europe are subject to an adjustment, which is considerable. A transfer price adjustment is a correction of the transfer price that arises at the end of a tax period. So what we have is, when you declare the customs value in the EU on the basis of a transfer price, if you then have an adjustment, consequently compensating adjustment, then the customs value that you've declared initially is wrong. So this creates a lot of risk for companies and a lot of issues to make sure the company is compliant with the customs valuation rules. In the EU, we have a case that you may know, which is called Hamamatsu, that was issued in 2017. And this case created a lot of complexity simply because the outcome of the case is not satisfactory for many people. And as you will see with the next slide, sorry, they're a little small. We decided to make a kind of a survey of the practices in the EU of how to deal with transfer pricing adjustment and customs value. And as you may see, amongst the panel of countries that are displayed on the screen, none of them has the same practice. So it's very, very diverse. In Germany, customs will use the fallback method. In the Netherlands, they're going to use the provisional value. In Spain as well. In Italy, you have the choice between the provisional value and the simplification process. In Sweden, they're going to apply strictly Hamamatsu. And in France, you can use either way, but customs authorities will prefer the simplification process. So it's very different in every country, which is the opposite of the purpose of the customs union. So that's why it's important that the reform takes into account these issues. The practical consequences, you may see it, is that, as I just said, every EU customs authority will have its own way of dealing with it. Some companies find provisional value too burdensome, especially when you have a lot of flows coming in. And this is, for me, the most problematic consequence, is that for one group that has an international footprint and various subsidiaries in the EU, they cannot apply one single mechanism throughout the EU. They have to go through different mechanisms, which complexifies everything. From a legal perspective, that creates a lot of risk. Rejection of transaction value, your customs value, then additional duties, penalties, and a lot of resources mobilized to address the issue. So this creates a very complicated context, and we don't have much options at the moment to overcome this absence of harmonization. Would it be for transfer pricing adjustment or other issues? We don't have a public database where the practice of EU authorities on customs valuation is displayed. We have EBTI, which is the platform that provides the binding tariff information rule issued in the EU, but we don't have anything on valuation. So we don't know how customs authorities in different EU countries are going to address one or more specific issue. We have what we call a compendium, which is a kind of a guidance from the EU Commission. This is informative but not sufficient. It will help reduce some non-harmonization phase, but always at a very minimum level. And it takes a lot of time to address when you speak between 27 member states. A way we have tried to develop is the use of what I was mentioning before, this Article 26. So you can, but it's not always easy. You can try to overcome this absence of harmonization of customs value in the EU by using a combination of Article 73 and Article 26. So you have an individual decision coming to you, and you're going to ask the customs authority of the country in which you're going to ask for the individual decision to extend it to other countries. But you have requirements for it. First, the effects of the decision must be limited to a certain country. It can't be EU-wide. And the second, you have to call on all the authorities of the countries concerned to make sure that they're okay that an individual decision that is issued in one country is going to be applicable to another one. So we have some in France. We've done it twice in the last year. Every time we had to make a call to customs authority in Germany or in Netherlands or in Italy to make sure that they were okay. Actually, not us, but the customs authorities in France do that as part of the communication between customs authorities. So it is a rather complicated process. It's not very streamlined, and it's in practice reduces the chances of using mechanism at a larger scale. So to overcome that, the customs value promotes now the customs reform now promotes the banning value information, and this is a very good news. It has been officially adopted on the 25th of January this year, so 10 days ago. It will start as of January 1st, 2027. So in about 3 years, you're going to have a mechanism in the EU that will provide for more harmonization on customs value issues. The scope of it is very large. It will include every aspect of customs value. So the method of customs value, the assist, royalties, R&D, also transfer pricing adjustment, which is a very good news. So we hope that this new mechanism will help overcoming lots of discrepancies that we see. It is expected by traders, and it should come along with the public database. So the banning valuation information that are going to be issued by authorities are going to be published online, which is very helpful because it will help us trying to see how specific issues are being addressed by certain customs authorities. It will be anonymized. It should be anonymized in order to protect business secrets. However, we think it's not sufficient at this stage to overcome transfer pricing adjustment issues, as I was mentioning. At the moment, an action is ongoing at the World Customs Organization to try to have a world harmonization on this issue that will help the European Union to speak of one voice on that and avoid the table that was just mentioned, showing before, where you have one country that keeps its own practice. We also have a new ECJ case on that issue that was just referred to the European Court of Justice in December. So we hope before 2027, this issue is going to be dealt with in the issue finally. Anyway, we're doing our best efforts for that. On customs valuation, it's also, as I mentioned by my colleagues before, we are not very sure about how the data hub is going to play. So the data hub is going to be a giant EU database with a lot of data on it. And as you may know, databases are allowed to be used for customs value, but only for the risk management purpose, not for the customs value determination itself. What we see in the EU is that there is a heavy reliance on customs valuation database, not only for the risk management, but for the determination of the customs value itself, which is a big issue and is completely contrary to the transaction value principle. Customs authorities, especially in the sector of e-commerce, will rely more on public database than on the sale price that is actually invoiced. And the more we have data, and the more the database is sophisticated, the more we fear customs authorities are going to rely on database to determine the customs value. So you see the trend that is quite worrisome, and we actually don't know where it's going to go. So this is one more open issue for the customs reform. I thank you very much. I will leave the floor to Agnieszka for the question. Thank you for your patience.
Thank you very much for all the presentations. Now we have some time for discussion, and as far as I can see, we don't have questions online yet, but we encourage you to send us the questions. Maybe we have some questions from the audience. Of course, we will have the opportunity to discuss all these matters like during the conference. Yeah, we have one question from Bert. Like we expect 14 to 15 years to introduce all the instruments, but it is now discussed, so we cannot be attached to this timeline yet. We believe that the works are speeding up and all discussions and all eyes are on this reform. So probably we will see like the law in the coming 1 or 2 years, because we are now discussing the law to be accepted by the Parliament and the Council. So this is the timeline we can foresee now. Thank you very much. Do we have like any other questions? Oh, perfect. Thomas, please.
So we saw in Fausto's presentation that there's a huge amount of customs declarations for the lower value, whereas obviously now with dropping the VAT threshold and the customs threshold, those should become revenue generators, let's say. Is there going to be a point at which the European Commission is going to evaluate the whole effectiveness of this system? Because what we're essentially doing is we're putting something in place for potentially not a lot of revenue, if we see it. Obviously, it's going to grow quite a bit. If I look at the UAE, for example, the Dubai Customs has a couple of times played with that threshold, increased it and lowered it as well. So I was just wondering a bit, is this the example to go to? And are we going to see an evaluation of it? And perhaps you have your own evaluation around the effectiveness of this reform.
Thank you, Thomas. I believe that you identified a sensitive point, because there are many ideas in relation to the impact of the reform. According to the impact assessment provided and published by the European Union, the benefit for the European Union should be the identification or better identification of the frauds, the reduction of the undervaluation of the goods cases, and the cases of split of consignments in order to benefit from the reform. The original reason of the exemption was the control of the burden of the activities requested by the custom administration. So one of the drivers of the reform is to support the activity of the custom administration, removing the 150 relief duty. It's a way to support the activity of the custom administration to speed up the custom clearance procedure, but is necessary also, in my view, to explain how it's possible for the custom administration to deal with the increase of the activity related to the custom declaration control and the resources that are needed to control the custom declaration that are submitted to the EU system.
The Hi, one quick question. In the United States, to be a quote importer of record, you have to have a title to the goods or a quote significant financial interest in the goods. So under the deemed importer rule, under the customs reform, is there a similar requirement that there be some sort of financial interest, whether title, a lien, some sort of similar sort of interest? Because the import of record in the US is where the liability flows.
I think it's a question.
Is that for Lars maybe or
Translating.
others?
Sorry, David, I couldn't catch the question in relation to the title.
Yes, do you have to have an ownership interest in the goods to be the deemed importer? Do you have to have title? Or can you just be some sort of consignee without title or ownership?
If in relation to the VAT and the taxation and the reform related to the deemed importer.
If I could, are you hearing me? If I can jump in. I believe your question has to do with title of ownership, and I believe the whole point of this reform, at least for me, is precisely to put a deemed importer not having title to the goods, acting as importer. And the expectation is that it will be the e-commerce platforms. So we're talking about eBay, Amazon, and so on, being the importers of record and effective importers. And to me, this is the big issue of this reform, because we are putting all the data in those platforms and all the collection of money in those platforms. So one question we could debate is, are we trusting 3 or 4 big operators with all the data and all the money of the importing that comes to the EU in e-commerce? And also, Thomas, the European Commission knows precisely how much they gained from abolishing the VAT exemption. They estimate in millions or billions. So that's why this is also a revenue collection measure. So we can discuss, I don't know if you have any views on putting the indirect representation and all the data in the e-commerce platforms, if it's if it's the right way to move forward.
Yeah, so exactly as Fausto said, in the EU, the concept is connected with the VAT concept of deemed importer. And as Katerina mentioned, the concept on VAT was created for the e-commerce platforms. So it's not connected with ownership of the goods or other roles, but to make an ease selling the goods via e-commerce platforms in a nutshell. Lars?
Yes, so maybe to respond to, if I understand it correctly, it's about do we rely on the information that we receive from whoever wants to import something and is then making use of somebody else who is a deemed importer, or this is the deemed importer, or making use of indirect representation. And this is exactly part of this liability issue that I mentioned before. It's, first of all, do we rely on this information that we see from outside of the EU, from whoever wants to import something? And then also the liability of the indirect representative at the end. Can this person rely on this information? So what do we expect from them to review this information? Is this trustworthy, yes or no? Because at the end, if it turns out that this information that the indirect representative received is incorrect, what's happening then? And I think the big fear is that this indirect representative is liable for whatever he was informed falsely. And this is exactly part of the huge criticism there, and where there needs to be some clarification, because otherwise this is or maybe even dead from the outset. So this is a law that nobody will want to apply at the end.
Thank you very much. So we are, okay.
Thank you. Now, just to jump on the second part of your question about how do we trust, I think this is the point of the trust and check status. To me, this is my personal view, but this status will be open to very few operators, and the platforms will be some of them. The point is to have real-time data exchange between the platforms and the customs authority systems, and only a few of them will be able to do that. So I agree with you that the reform is towards this platform to make sure that we avoid undervaluation and escape of customs and VAT, customs duties and VAT. And for the trust itself, this status is going to be implemented for that. I'm not sure that it will be helpful for other companies than platforms.
Jesus has a question, maybe on platforms, e-commerce platforms.
No. The question is precisely on the matter of the transfer pricing adjustments, because okay, sometimes here as you know, Thomas, and here in the GCC, we are looking for the European Union in order to see what are the practices there in different issues like invoicing, for example, customs matters, VAT, of course, the ECJ decisions, or the possibility of interpretation principles that could be implemented, imported here. And what we are seeing is that there is no still clarity about the matter of the transfer pricing, the impact on the transfer pricing adjustments on the cost of valuation. And of course, I think that a concern for us, now that transfer pricing rules are going to be mandatory from 30 June 2024, 1st January 2024 for the majority of the companies, due to the implementation of the corporate income tax here in UAE. Now, there is a real concern about how we are going to, let's say, formalize these transfer pricing adjustments. Okay, we are talking about, we have two options. Or there is any charge, no? Or alternatively, there is an adjustment on the COGS, valuation for customs purposes. So I think that it is a matter that when here we are going to need clarity as well, as it happens in the European Union.
Thank you for your comments. Clearly, the EU cannot be seen as an example for this topic. Unfortunately, we haven't made it yet. I mean, each country is doing its own thing. The ruling of the European Court of Justice has been criticized by everyone. So definitely, we are not an example. Some other countries have a more harmonized and advanced way of dealing with it. You've got in the United States, in Canada, in Southeast Asia, you've got some countries like Taiwan, for example, they have a pretty good system. Korea has an excellent system. What we are doing at the moment within the WCO is we are trying to have the WCO adopt an instrument on this. But that requires that every country in the world agrees to the instrument. So there is a political and a technical desire to have an instrument. Now the outcome of the instrument remains uncertain. What we are pushing for is simply the recognition of transfer pricing adjustment as part of the transaction value. And if we have this recognition worldwide, then each country is going to be able to work around this principle and have his own way of dealing with the subject according to his own national specificities. But at least the principle is there and everyone is on the same line, which is not the case now.
Basically, you are going to need, the companies are going to need any kind of specialized advice, no, in order to manage it. Okay, for example, because we know for different firms that they are already advising with respect to the specific approach to the tax authority, but this is a matter, as I mentioned before, that here is a new world. Because of this recent implementation of corporate income tax in this country.
It's interesting because this is also the point of that's why we're going to WCO level to have an instrument worldwide that will help in countries where you lack of guidance. Because I understand from what you said that here in the UAE you don't have much guidance on it, so it's pretty much a case-by-case analysis based on who you are and what is your business. So if you've got like international guidance, at least that will give you something like to rely on. But obviously, based on that instrument, each country is going to have to set up his own mechanism, and then it's up to each federations and trade operators association in each country to push for a better handling of the matter. But if you've got like an international instrument to help you with that, at least it's pretty important in your business case.
Then another comment is that related to let's see how is going to be implemented all these regime with respect to OEMS, OEMS in the European Union, because as I mentioned before, depending on how the things are going to work out, maybe here in the GCC, once we have a real intra-GCC, okay, VAT framework, and because we currently have not, okay, let's see how this matter is going to be about, because I think that is quite interesting.
Thank you. Yes, it is.
So thank you very much for your input. We highly value the vivid discussion about the EU customs reform. We believe the reform will bring many topics to discuss in the future, which we know now, and new ones, because the legislative process is still pending, and we can expect some more developments. As Arnaud said, there are needs which are not addressed yet, so we expect to have even more new instruments to be discussed and then maybe implemented. Thank you very much. We have now a coffee break, so please enjoy your coffee and your discussions further, and we can get together in like 11 minutes now or 10 minutes. So it will be 11:45 to meet again for another panel. Thank you very much.
There's a couple of people still coming in from their coffee break. we heard earlier about EU customs reform, and I'm gonna start and coin a phrase which says that when it rains in Brussels, it will drizzle in Riyadh, because obviously the WCO being in Brussels and the European Commission in Brussels, what we see is that the GCC will often look at other countries as a benchmark, and the EU, and you look at the level of progress and refinement and the nuances which are being added to the system. It's definitely something to look at. So if the customs reform is successful, then I have no doubt that at least parts of it are going to come here. And I would say, who better than my friend Professor Atiya Hussein from the University of Sharjah to talk about customs compliance in UAE free zones. She has studied and done her PhD in Europe, so she can perfectly compare a bit the two systems really. And I think for those of you who maybe are less familiar with the country as well, she's going to explain a bit what free zones are and what the success constitutes of the free zones in the UAE. So I'd like to invite you up on the stage, Atiya. I wish you best of luck with the presentation.
A very good afternoon, all of you. Thank you so much, Thomas, for the introduction. And it's lovely to be here. Such a wonderful conference going on. Just a brief introduction of myself before we start. I'm Dr. Atiya Hussain, and I have around 13 years of working experience working in 3 different regions, including Asia, Europe, and since last 6 years, I'm based here in the UAE market. Quite interestingly, because I have been part of one of the big 4s, so I have collected practical experience working on different clients in Germany as well as here in the UAE. And 2.5 years ago, I jumped to academics. And the main idea was basically to connect practice and academics and to create a bridge between academics of this area and practice, so that students can actually, when they land to the job market, so they are well versed what is happening on the ground and what are the practical realities in terms of the tax. So this was the main idea. Over today's topic is UAE customs compliance in the UAE free zone areas. And before I actually jumped to the agenda, which is here. Yeah. What is the main motivation of this study? So this is the actual study which I conducted along with a couple of my colleagues in the university. And I will be honest with all of you that why I actually conducted this research. Actually, what happens that you work something in theory and then you realize it in the practice. In this case, it was the other way around, because I was advising a lot of clients here in this region who are based in the free zone areas. So they were facing these difficulties and challenges, which will be highlighted here in this presentation. And then after advising them, after having a direct feel on the ground, so when I jumped to the academics, I thought this is a really good topic where we should explore further and we should validate this, prove this with the help of the theoretical background and actually hypothesis and collecting of the data and all of this stuff. So the topic is here. We will start with the UAE environment, tax environment, and especially for those who are coming from abroad. So it will be good actually to have this. Free zones in the UAE, research questions, empirical studies, hypothesis, methodology, data collection, variable and study model analysis, and conclusion and the future research. So this is the agenda. Let's start with the very basics. Tax. All of us know what it is. Like many other countries, it is subdivided here in the UAE as well, direct and indirect taxes. I would say 2 years ago, it was just this side, only the indirect taxes. And if I just go back also 6 years ago, so it was just customs portion in the indirect taxes. So customs has been always part of the UAE one way or the way, but it took its institutional form back in 2002 when all of these 6 GCC states, they come under one GCC common customs law, and then it was formalized. If we talk about value-added tax, So value-added tax, it was implemented on 1st of January 2018 at the rate of 5%, like many other countries. So for a longer period of time, this country has been heaven for those who are having businesses here without payment of any kind of taxes other than the customs duty. Then in a couple of months ago, before the VAT was introduced, also the excise tax was implemented here in the UAE. So, and on specific products. And then I would say 6 months ago in June, and then starting from this January, for some of the companies, the corporate income tax is also introduced. The only thing which is remaining is the personal income tax. And I think so who are working and living here, they're lucky enough to not to have any kind of personal income tax. But I would say specifically in the last 6 years, the UAE market has evolved a lot around the whole tax environment. So this is great. As far as personal income tax is concerned, this is another research project which are still underway, and probably in the next conference, I would be able to share the results and findings with all of you. But over today's focus is none of the others, rather only the customs duty right now. Now let's jump to the free zones in the UAE. The concept of free zones in the UAE is same, like we have any of the other global country, any country, you name it, like we have in Germany, like we have in China, like we have in Canada or Australia, but the name or the term itself might be different. Like in Saudi, we are using this economic zones. Here in the UAE, we have free zones. So why I have picked this topic, because the significance of the UAE free zones here in this region, it is really, really important. They are contributing a lot to the GDP. There are 40 plus free zones in the UAE itself. Out of them, 20 are in Dubai, and rest are based in the other Emirates. One of the biggest free zone, which I will highlight here as an example, is the Jebel Ali free zone area, which is based in Dubai. It is one of the biggest zone in the area, free zone area, and it's commercial hub for many companies, more than 10,000 companies from different countries, 140 different countries. They're based here, they're having operations here. And of course, they are enjoying the benefits of the free zone. As I said, it is similar in nature. The benefits are similar in nature like we have in any of the other countries. So here, the rate of customs duty, of course, it is the standard rate of customs duty for the import of any goods into the local market, which is mainland area, it is 5%. But when we talk about free zones, so it is 0% rate of customs duty in any of the free zones here. Of course, this is one of the benefit. Then 100% foreign investment, businesses are easy to start up. Fine, these are the all benefits, these are the all advantages. But if you look into any of these stringent, or you can say strict requirements, what are those? Are there only benefits which the free zone companies are enjoying? No, there are not only the benefits which the free zone companies are enjoying here, rather there are also certain requirements which become actually serious in nature in the last couple of years, specifically after the implementation of the VAT in 2018, 2019. So what are those requirements? Apparently, the issue looks very simple, but when we have a deep dive, so it is not that simple. It requires a lot of paperwork, it requires a lot of homework, and it requires a lot of proactive actions, which the companies should take if they want to establish, if they want to set up a business in the UAE free zones. So over focus of this discussion would be those requirements. What are the challenges which the businesses are facing? And what are those requirements? These are those requirements. In a simple format, I have provided here. What is this? This is basically the inventory management system, which all the businesses based on the free zone specifically are being required to maintain either manually or electronically. So that what does this tell us? Basically, it tells us that whatever you are bringing into the free zone, transit in, and whatever is going out, outbound, transit out, they should have a proper maintenance, proper record of these transactions. So probably my colleagues from Europe or any other country, they might be thinking, so what's different therein? So the problem is that when there was no VAT structure, or you can say excise structure, or the tax structure itself in the UAE, so the free zones businesses, they were taking this kind of requirement very easy. They were not properly following these regulations, the businesses, so they were not properly maintaining this requirement. And what happened after the implementation of VAT in 2018, the customs authorities give 1 year time slot, basically not formally, but it's a kind of implied time slot which they give to the businesses. And then afterwards in 2019, they started issuing customs notice to the businesses who are based in the free zone. So the notice was basically, to share their stock sheet, or you can say their stock reconciliation sheet, inventory reconciliation sheet, whatever they have imported into the free zone, where it is, whether it is disposed of, whether it is brought to the local market, whether it is being re-exported, whether it is still there in the warehouse, where exactly the stock is, they need to prove this versus transit out. So specifically, the focus of the customs authorities is, and was in the last couple of years as well, it was regarding the value, quantity, and weight. The last three columns, you can say quantity, gross weight, and value, and here as well, quantity, gross weight, and value. Why was it? Why it was required? The main thing is that in the region, in the UAE, the customs, the free zones are considered as foreign territory from a customs standpoint, not from a geographical standpoint, of course, they are part of the UAE, but from a customs standpoint, they're considered as foreign territories. So when they are considered as foreign territories, so it means that law allows them to bring in the goods without the payment of customs duties, but it does not mean that other customs regulations are not applicable. The other customs regulations, filing of the customs declaration, maintaining of the record, declaration of the correct value, correct weight, correct origin, all of these details in terms of weight, value, and quantity, they should be properly declared. And here was the lacking and the businesses that they were not properly maintaining this. And then what happened, this requirement actually, what was the implication? The implication is basically that if the businesses are unable to justify the stock in and stock out, so there will be a gap. So on that gap, it means let's assume if the business is importing 10 million dirham worth of goods in a given year, and if they are unable to justify to the customs authorities 4 million dirham worth of goods, they don't know where they are. So number one, customs will imply that they have imported these goods or smuggled, basically smuggled is the right word as per law, smuggled these goods illegally into the local market and without the payment of the customs duty. So it goes to basically the customs duty evasion and smuggling. And then there are, of course, penalties. I will come to that part later on. So on this gap, if there is a gap between transit and transit out, so then the customs is going to have penalties on that amount. So this becomes really tricky for a couple of our clients back in few years, and still this is the problem. So this is the issue which we tried to further explore with the help of theoretical research. And what did we do? Here we have further on. This was a research question. One of the motivation behind this research was actually, scratching the ground further. Number two, realizing the awareness among the free zone businesses and the advisors that this issue is not simple. They need to take it seriously. They need to have proactively the compliance requirement they need to fulfill. Otherwise, of course, they will be heavily penalized with the monetarily, as well as, of course, it's an administrative burden on the businesses. Because how it is an administrative burden? See, every day the employees are coming to the work. They have to work their 8 hours or 10 hours, how long they're working. So they have to, their daily operations are there. But at the same time, if there is customs notice, and if they are not properly maintaining records, so what will happen? This is an additional layer which they need to sort out in order to answer the customs queries. So this becomes really problematic, and specifically for the businesses who are established in the UAE for years and years. Like there are businesses who established probably in the late 90s in the free zone, or early 2000 when there was no taxes here. So this becomes really tricky for them. And other kind of businesses who suffer a lot from this, they are, for example, if they are dealing into fast moving consumer items, if they are dealing, for example, in aviation, so probably it is quite easy for them to prove where are the aircraft, right? Because they are physically very heavy. But if they are dealing into fast moving consumer items, electronic items, or baby products, or any small items which we are consume every day, so really it becomes difficult for them to prove where is the stock, right? So that was the issue. Then we explored further that how it can be improved. This is a challenge, this is a problem, we know, but how it can be improved. Can we advise or can we prove theoretically by collecting the data that internal audit function, internal control, compliance, fulfilling the compliance requirement itself, and the record keeping? If they do all of this, so are there any positive changes, or is it possible that they can actually overcome this challenge faced by the UAE free zones businesses? So for that purpose, we have some of the empirical studies and hypotheses that we developed. These are the studies which have been done in the last couple of years, not specifically for the UAE market, not specifically for the free zone businesses, but overall for the inventory management in different parts of the world. So the novelty of our work was basically that our focus is the UAE market. Then we highlighted the significance of the free zones because a lot of, as I said earlier, let alone in the JAFSA, Jebel Ali free zone area, there are more than 10,000 businesses who are established. So based on these studies, what happened, then we set the hypothesis, and the hypothesis is basically, it revolves around four main things. Relationship between inventory management, because if we bottle down, this whole compliance requirements revolves around the inventory management. So in relationship between inventory management and the internal control, if they are going to have any kind of measures, if they are taking proactively, if they are going to maintain proper records, if they are going to have internal audit function, and if they are properly doing what? Internal audit, fulfilling ultimately the compliance rules and regulations. So these were the four areas around which our hypothesis revolved. And we, what did we do then? We actually, this is the study model. Inventory management is on one hand, and then we have the other four factors. So it was quite challenging actually. And I will be honest with you, it took me 1 year to collect the data. In 2022 full, and start of 2023, we collected the data. And how did we collect the data? We prepared the self-administrated questionnaires. And then we reached out to different free zone businesses who are based here in the UAE. We reached out to different tax advisors, practitioners who are advising those free zone businesses. And then we were successfully able to collect questionnaires rightly filled from 207 different companies, 207 different persons or personnel, you can say, who are based here in the UAE and who are working and advising or part of this whole challenge or problem. Then we used software in order to clean the data, coding, whole process. And then ultimately we concluded what? Here's the variable and study model. You can see this equation we have theoretically, probably for some of you, it will be giving you a backflash from your student's life, or maybe one of the research course if you have taken. So this is what, but again, I would say that because I have seen this actually happening on the ground, actually I have seen this practical challenge while advising to different clients based in the free zone area. So I was like, this was really close to my heart that yes, this is what is going on the ground. So we have to theoretically prove this as well. So we have on one side inventory management, starting with INM, and then we have record keeping, internal control, internal audit function, and this is further divided into different sub-factors while we prepare the questionnaire. Here we have some of the descriptive statistics. And here we have the correlation metrics. So you can see that if I just give you a flashback again, some of these statics and double statics, these show basically that what kind of relationship they have, whether the relationship is significant or not significant. So for most of the cases, for most of the components, the relationship was significant among all of these variables. And here is the main result. And to be honest, when I was preparing, when I was into this work, I was thinking that probably the main good result, or you can say the main factor on which the whole model is dependent, it would be internal audit function, or if the businesses will have internal audit, or if they take internal control measures internally, proactively, so they will be, they will be able to solve this issue. But surprisingly, the result was that if you see the first column, which stands for REK, record keeping. So if you look into this R value, which is the main value, if some of you know the statistics in terms of how do we interpret this. So statistics, you can say it's 66% of this whole model actually revolves around the record keeping, and which makes sense. How? Because if the businesses are maintaining record, and record of what? Record of all of the transactions which we are bringing into the country, bringing into the free zone, basically. Commercial documents, bill of lading, packing list, commercial invoices, all of these documents, if they are maintaining, I would not say for a specific number of years, because in the mainland, we have a different requirement. In the free zone, we have a different requirement. So if they are maintaining, since the business is established in the free zone area, and if they are maintaining these documents over a period of time, then even if they are not having, of course, we cannot ignore the importance of internal audit function or internal control. But at the same time, what we can say, if this is the one thing which they can do, record keeping properly, right? They archive, whether physically or you can say electronically, so they can resolve this issue. As and when the customs authority will reach out to them. They will have all of these records for all of these transactions. And of course, they can save themselves from the label of smuggling or deemed smuggling, you can say, without the payment of the customs duty. They have been, so they can definitely save this thing. So record keeping was one of the main element which we analyzed, which we found out that this is the most important thing. Then we have also the compliance requirements, internal control measures, if they're going to take. If they have internal control measures, what it could be. I'm saying internal control measures, fine. Internal control measures means basically that if they are storing the goods in a warehouse, of course, in Jebel Ali, let alone talk about, so there are so many warehouses which are big enough, and sometimes what happens that the businesses are sharing the space, different space they are sharing within one warehouse. So if the warehouse is having proper CCTV camera, if they're having proper manual or electronic records, if they are having proper warehouse keeper, if the records are properly being maintained, so automatically what are they doing? They're fulfilling the compliance requirements. So this is another internal control measures which they can take. Apparently, it's quite simple, but as I said, because the businesses, when they established here, so there were no such kind of tax environment, so they did not take it seriously. But now I think so, once the customs authorities have started the audit and some of the clients, some of the businesses have been heavily penalized, so now they are probably gradually realizing the importance of this strict rules applicable here in the UAE free zone areas. So all of these things, you can say, they add or they facilitate, they support each other. But the main thing is the record keeping, which of course they are required to maintain, so that as and when customs will come, so they have something in hand. Rather, I would say they have everything in hand, and then they just need to share the stock report with the customs authorities. Here we have some of the other analysis, reliability for the model. Based on the results, based on the data analysis, based on the study model, so we ultimately accepted all of the hypotheses which we have said. And of course, if the business is having proper record keeping, proper inventory management, or rather, let me put it this way, proper record keeping, automatically they are having an internal audit function, because one way or other way it is, or internal control measures, you can say, and ultimately it leads towards the fulfillment of the compliance regulation, which is required here in the UAE free zone areas. So the UAE free zone areas, they are established by the UAE government, His Highness, that for the, of course, to give leverage and platform for the foreign companies to establish business there and run their operations. But at the same time, there are regulatory requirements, there are compliance requirements, without the fulfillment of which, of course, they cannot fully enjoy the benefits. So they need to take care of this. And the main purpose of this study was to create awareness among the business society, the businesses who are already established, the businesses who want to establish in the UAE. So proactively have this inventory management mechanism, so that later on down the road, when the customs knock their door, so they don't have to, worry about, and they don't need to land into an administrative burden, a lot of work. And again, they can save themselves from the monetary penalty as well, fines as well. And what is the penalty basically? Let me come to that part as well now. It's standard rate of customs duty in the UAE mainland area is 5%. But when we talk about monetary penalties, because it is considered as deemed smuggling, because it's a, you can say it's a foreign territory, the UAE free zone, and when they are bringing in the goods, or when they cannot justify that where the goods are, so it means that ultimately the penalty amount will go up. It will be equal to 10% fines and penalties, and of course the payment of the pending customs duty, which they consider. So it means in total, the example which I gave earlier, that out of 10 million, if the 4 million worth of goods they are unable to justify, this is the gap. So it means on the 4 million worth of goods, total penalty amount will be 15%. And the UAE customs authorities, they're very generous, very cooperative in this context. So they know actually what is the ground reality. So on that basis, of course, if the narrative is properly set, if we can justify, so probably there could be some kind of relief in the duty, in the fines as well. And this is something, as I said earlier, a lot of businesses are facing here this issue. Not only, an interesting part is not only the companies who are dealing or manufacturing or who are dealing in the goods, rather some of the banks who are based in the free zone areas. And you might be thinking banks are dealing in the services. They are the services providers. What kind of issues, how they are facing this kind of inventory management issue. So the thing is, the banks or the services provider need to think about this, that whatever they are importing into the free zone, wherever they are based, regardless of this, that it is commercially used or it is used for the business purposes, like within the bank. Banks are importing, let's assume, different, you can say, souvenir, different laptops, computers, calendars, all of these stuff they are importing. And even if they are importing for their own employees, so on this, they also require to have some kind of inventory management, whether electronically or physically, so that by the end of the day, when the customs knock their door, so they don't have to worry about, and they can easily populate the stock sheet without having any gaps, which ultimately will save them from the penalties. So what else we have, what we can conclude that if we look into a broader perspective, so ultimately what will happen if the businesses are properly operating, if the free zone businesses are enjoying their benefits which is granted to them, and at the same time fulfilling the rules and regulations. So what will happen? Of course, we can move ahead towards the 2030 goal of the SDGs, Sustainable Development Goal of the United Nations, and we can have a, you can say it's the decent walk and economic growth. Ultimately, we can head towards this and we can contribute to the society. This is not the end. Just we have something else in the future research. We have found out that this is what is the challenge. This is how they can sort it out. Now, the future research, what we can extend this research is that other than UAE market in the GCC region or other than GCC region, are the businesses having the similar kind of practices? If yes, can we apply the same factors? So this is another area of research which we can have. And what else we can do? We can empirically analyze, yes, we can empirically analyze that these factors, if they are actually implemented, the record keeping, internal audit function, control measures, so how can they help the businesses to reduce actually, and how much actually the duties can be reduced or fines, not the duties, rather I would say the fines and penalties can be reduced. So these are the two further areas where we can explore further. Either in the UAE or, beyond the scope of the UAE as well. And here we have in the end, a couple of references only selected, of course, when you do research work. So there are probably 100 different selected references, but I just picked up the first lot, starting with A. And there are so many other references which we used for this work. Thank you so much. And if you have any questions, please let me know.
Thought I'd maybe kick off the questions already for you, Atiya. Thank you very much for your presentation. I thought maybe for the benefit also of the wider audience to ask you a couple of practical questions, but to also share some of the experience around complications, which I know that we've both dealt with as well. Referring to, for example, Jebel Ali Free Zone, we have at the end of this row our dear friend Wim sitting, whose company is licensed by JAFSA, but sits physically not inside JAFSA. And what you have in terms of the complexity with the Jebel Ali Free Zone, for example, is that indeed, number one, you could have companies licensed by JAFSA but not in JAFSA, and JAFSA would be, yes, customs exemption applies, but not for businesses that are bringing their goods outside or that are sitting outside. At the same time, for example, from a VAT point of view, we have a list of designated zones where no VAT applies for any import in it and no VAT applies for any sales within the designated zone, barring exceptions. But the delimitation of that zone is again not the same as the geographical zone of, for example, Jebel Ali Free Zone. Moreover, from an excise tax point of view, another tax, the designated zone is not automatically a warehouse for excise tax purposes as well, and that needs to be separately licensed. So I think when talking about compliance and control, it shows you also that any regular business could quickly be caught in non-compliance with this. And I guess that leads me to two questions for you. Is we talked a bit about Jebel Ali Free Zone and compliance. Is to what extent have you seen in your experience leniency from the authority around the application of penalties when indeed there's a shortage of inventory, transit in, transit out? You have a shortage of inventory, you get customs duties applied. To what extent can you say, sorry, it was my bad, really, and I made a mistake, but I won't do it again? And I guess the other question that I had as well is what we see in practice as well, but then less linked to free zones, is We see sometimes on an individual basis, customs exemptions granted or under special laws. For example, imports done for supplies for Abu Dhabi National Oil Company or its affiliates, you would not have any customs duties applied, but only in Abu Dhabi, not in Dubai. And do you have a view on how wide that range is of the different exemptions individually in specific laws? And do you have a view on how that makes matters complex? For example, in the case of ADNOC, essentially using JAFSA might not be that useful because once you bring the goods to the mainland, you still have customs duty. Whereas actually, if you had brought it to Abu Dhabi 1 hour away, you'd be benefiting from the customs exemption.
So thank you so much. Quite interesting and practical questions. To answer your question number one, regarding the leniency of the UAE Customs Authority, and let me recall my experience advising different clients and actually dealing with the customs authorities, coordinating with them. So I was kind of playing the role of middlewoman as an advisor also. On one side, it was the company, and the other side, it was the authority. And I will be honest with you, the UAE customs authorities, they are very cooperative. First of all, how they are cooperative. Previously, when they started this whole customs audit thing, so it was like they just send you the notice and then you are supposed to share the stock sheet within 5 working days. So which was then they realized soon that it is a very short time period. So it is quite hard for the businesses to, share the stock sheet within 5 days. Then they extend this time period to 3 months, subject to the further extension. So this is one of the things which they really want to support the businesses to actually follow the compliance and the rules and regulations instead of just focusing on the monetary penalties. So aim is not to have the monetary penalties, rather to actually, you can say, push the businesses or encourage the businesses to have the compliance with the rules and regulations. This is one thing. Secondly, when it comes to the leniency in the penalties, so yes, if we are having a proper narrative, and when I say proper narrative, so it means that we are properly justifying with the help of the numbers, with the help of having the backup in terms of the documentary evidences. So whatever we have transit in, for example, if there are 3 or 4 different segments, this is what we have in hand. This is what is to be honest, which we can say it is being destroyed. And of course, then you need a destruction certificate as well from the municipality. You cannot simply set the narrative that you just destroyed this stuff. This was quite obsolete or old. And then we have also, let's say, if we set the narrative that it was caught fire or it was re-exported or it was, you can say, brought into the mainland area. And this is the stuff which we don't know actually where it is. So they have right to inquire about all of the documentary evidences. In some of the cases, they may inquire. In some of the cases, they don't look into this. Like they don't ask for the further documents and they go ahead with the narrative which we have, which the businesses explains based on the trust relationship. Then on the gap, of course, they apply the relevant customs penalties, fines and penalties, and they might provide some kind of discount or reduction as well. Or of course, I cannot say 5%, 2%, 3%. This is quite variable. It depends that what kind of gap it is, what is the reason of the gap, and how we are going to justify this. So if it is honestly, properly, with transparency, if it is justified, so the authorities are very supportive, very cooperative, and they want to facilitate the businesses instead of just merely imposing the penalties. So I have personally, I remember one of the clients, of course, I cannot name the client. So the penalty was 150,000 dirham. And it went down to, you can say it was between then 110 and 120, somewhere it landed. So we were able to have some kind of reduction in the penalties because of, because of transparency and honesty, whatever we have shared with the customs authorities. Second question was regarding the state-owned companies. So I would say because here we have 7 emirates within the UAE. So Abu Dhabi, Dubai, Sharjah, all of us know how many we have: Fujairah, Ajman, Ras Al Khaimah, Umm Al Quwain. So as far as Abu Dhabi is concerned, being capital, and of course, one of the, for such kind of state-owned companies, Of course, there are certain agreements where there customs duty exemption, or you can say special discounts or special customs duty exemptions are being provided. So of course, we cannot compare it with JAFSA because the nature of leverage or the benefit with companies which are based in Jebel Ali or any of the other free zones they enjoy it is different. And the nature of state-owned companies, the kind of exemption which they have a tax bracket for, let's say 5 years or 10 years, which they enjoy it is relatively different. So as far as Abu Dhabi mainland is concerned, and of course, if a private company or any such company which does not have this kind of benefit or which is not state-owned, so then of course they have to pay the equal penalties, not the penalties, right, the rate of customs duty, which is 5%. Yeah. Yes, please.
Thank you, Doctor, for your interesting presentation and research. My name is Ayman Shanik. I am Customs and Trade Facilitation Advisor for Abu Dhabi Customs. And I just joined recently Abu Dhabi Ports Group as a Trade Facilitation Advisor. I spent 14 years in Abu Dhabi Customs, so I'm aware about the procedures and the policies. Just be patient with me. I have some comments and I have some questions also at the same time. We just need to rephrase that there is no taxes or it's 0% in the free zone. It's not exempted. It's a duty suspension. And even in the GCC customs law, it's a duty suspension. It's not exemption. So we should take that into consideration because duty is applicable as soon as it's released to the local market. So and we should also differentiate between the designated zones and the free zones because we have some specific free zones in the country, but it's not designated zones, which means that the taxes is applicable inside this zone. This is the first comment. And the second, I'm not sure if you take into consideration in your study the compliance requirements for the raw materials for the factories. You just mentioned the inventory and the warehouse management solution. But you know, we have some complexity when it comes to the factories because they are importing raw materials, they are exporting or they are releasing from the free zone ready-made items. So did you take that into consideration, how to enhance the control or enhance the internal control solutions for the companies inside the free zone? The second question, did you take also into consideration your study the transfer of the ownership inside the free zone? Because you know, inside all the free zones in the country, transferring of the ownership is you can transfer the ownership of the goods and you can sell the goods within the same free zone. Is there any specific requirements, compliance requirements for the companies who are intent to transfer the ownership? And the last one is, or the last two questions, what is there any difference through your study? Did you notice any difference in the procedures, entry and exit procedures among the free zones in the UAE, for example, Abu Dhabi, Dubai, Sharjah? And the last question, I'm not sure who's legal here and who can answer this. For the public warehouses in the free zones, if any smuggling happens, who will be responsible for the penalties and the duties, the importer, the consignee, or the authority who's managing the warehouse? Thank you very much.
So thank you so much for the list of questions. Interesting, quite interesting. And I hope so. I will have all of these in mind while I will be answering your questions. So please remind me again if I miss anything. First of all, you mentioned regarding the customs duty suspension. Yes, absolutely, you're right. This is the legal term which we use. But as I said, when we explain to the clients or when we use in our daily life or when we have discussions, so usually we said, okay, the rate of customs duty in the free zone, it is 0%. So it translated here in this presentation as well. That's correct. Secondly, when you said that designated zone, yes, I totally agree with this, and especially with reference to the excise tax. There are a lot of free zones which are not designated zone or designated zones which are not free zones. So it's like quite tricky area. And that's why in the start of the presentation, I said that over focus is not excise and not VAT, rather only the customs duty right now. From a customs duty perspective standpoint, we are just going to highlight this discussion. So yes, I do agree with this point as well. Third point is regarding the involvement of the raw material, I think, so which you mentioned. So we actually had a broader level of questionnaire, which was, you know, when I was preparing this questionnaire, so one of the challenge which I faced was that first of all, getting to know that how much people are aware of this, because in most of the businesses which I have seen based on my personal practical experience, the businesses based in the free zone, either this kind of function, this inventory management or compliance requirement, either it is managed by their procurement or purchase or finance. So the concept of having a separate tax function or separate audit function, I would say that a couple of years ago, this was quite new to the businesses who are established in the free zone. So whenever we are advising them, so we used to tell them the significance of having tax function, significance of having customs function itself, separate, at least having dedicated resources. And just think about it. If there are some of the, let's assume if there are 5 resources who are managing the whole customs function in a company, and what about those people who are like, let's assume if they're working into any of the other department, let's say if they're working into accounts, or if they're working into admin, right? So this was another problem which we actually highlighted while advising one of the clients, that the if few of the women working in the admin department, they have imported some stuff from outside the country by using the importer of record number of the company, instead of, instead of shipment going to their private address, because during the working hours, they're receiving the parcel, so they received it at the company, right? So this is another area where actually the awareness and the education of this whole compliance, this is required. This is not only the job of the customs, the people who are working in customs, the people who are working in tax function, rather it's a kind of general awareness which each and every employee should have who is working and who is part of the free zone businesses, so that not to, you can say, use the customs code of the business where you are based, for which you are working for your private import. So this triggers problem as well. So as far as raw material is concerned, just to answer your question, these were the kind of challenges. So we just made the questionnaire more simple, and probably this is something which we can extend over further research. In the next phase, we can definitely include this as well. Light assembling is done in free zones, and then of course the goods are being imported out, transit out by paying the relevant customs duty. Yes.
I think in this regard, one of the conclusion of your study should that whether the customs administration or the entities in the free zone should adopt integrated solutions, relying on the manufacturing formulas, which means that each company should have their manufacturing formulas accepted and approved by the customs administration, and there should be integrated solutions to make the life easier for the companies and the customs.
Absolutely. Yeah, I agree with you. Yeah, thanks for this valuable feedback. Is there anything pending? Any questions? Was the last one, was anything?
Actually, it's regarding the difference between the procedures between the
I see, yes. So yeah, difference between the procedures of different free zones based on different emirates, right? So this kind of procedure, theoretically speaking, this requirement of maintaining inventory management, having compliance requirement, and of course the amount of penalties, this is stated in the GCC law. So this is equally applicable in all of these emirates, right? But at the same time, I would say that based on my personal experience, which I have seen, this requirement is more stringently applicable here in Dubai. In Sharjah, this is relatively, you can say they are more tolerant, you can say, or in Abu Dhabi, I have also seen after they have this whole reform. So this is also applicable there. As far as Fujairah is concerned, Ajman, so this requirement exists. This is there. How far the businesses are practicing and how far the customs authorities are tolerating this is another discussion. Thank you so much. Any questions? Any further questions?
There's a couple of questions online or over there as well. Maybe you can pass the mic to Iman.
Reflections here on the discussion. My name is Ayman Al-Awadi from the corporate group. We are based here in the UAE and we operate from Dubai, and we have offices in Riyadh and Oman. What we do, we attract foreign direct investments into UAE for incorporation and post-incorporation. We are also one of the strategic members of partners of Dubai government, the issuing licensing authority, Dubai mainland, and also at the UAE MOFA level, Ministry of Foreign Affairs. My interaction here is that the free zones and the mainland creating competing legal systems for all the foreign companies and local companies, but yet is giving you a superlative advantage where you can choose the jurisdiction that fits your need and operate from. Though it creates confusion because, as you said, there are free zones, which is bounded free zones, and then there are some free zones are situated within the city, and you don't feel that you are exiting from the free zone. And those ones are more or less catered for service, business activities and consultancies, while others, which is bounded free zones, are designated for products because they do have warehousing infrastructure. And having said this, Dubai Free Zone Councils is the overall umbrella of all 27 free zones within the Dubai to govern the performance and the collaboration along all these free zones to make it more of competitive, to create a global, competitiveness and performance across all free zones, because the aim is to make UAE as a superlative model to operate free trade zones as a jurisdiction. And having said that, one of their projects is to unify the company registrar to have one license that has one profile across all trade license, across all trade zones, and that makes our job much easier, because today if I want to fetch records of companies as a company directory, I have to go individually each free zone separately. But this is going to be coming under one unique number that mainlands and free zone, they will all share one ecosystem. The Dubai Free Zone Council will be overseeing this project and making things happen. I think these ones will also add value and advantage to the ecosystem that is currently having when it comes to compliance and customs duty. Thank you.
Absolutely. Thank you so much. And for this valuable insight. And this is really wonderful. And I can imagine that if a business is able to have one license for all of the free zones, right? This is what I understood, right? So this will be great. And I think so this is a great initiative, and which will really help the businesses. And again, as I said, it's a beautiful country, and the government is actually facilitating the businesses. They are not only attracting the foreign investors, rather they are, you can say, they are here to ease the business, to perform the daily operations as well as the compliance requirement. And it's not about the monetary policies. It's not about to make the life of businesses hard, rather it's to facilitate them. And this is one of the great initiatives. Thank you so much for sharing this. Yeah. Any further questions?
There's a couple of questions online, but I think we don't have time enough to answer all of them. We'll be breaking in a bit. This will be the last question, and then we can go up to P3 where lunch is served, and then we will come back at around 1:30, 1:40 probably. There's 3 questions online, and I'm going to pick one of them because I had an interesting exchange with I don't know where Christian is sitting, but one of his colleagues sitting in Germany. Who was really zooming in on the point on the possibility when you're a free zone company to trade with the mainland or not. And I guess I was in our conversation showing a couple of the, let's say, the reality of some of that. And my counterpart in Germany had a bit more of a rules-based kind of look on things, and had difficulty in grasping this. So I guess the question to you is that was asked online is, it is said that legally a free zone company cannot trade with the mainland. Can you explain more about this, if this is true, and how can a free zone entity trade with mainland entities?
Well, it depends on, so we should go to the basics. If you want to start up or having a business, established business in the free zone, so you need to have certain regulatory requirements. You need to have the trade license. You need to have a customs client code. And of course, if you have a warehouse here, of course, because the customs moves with the physical movement of the goods. So in the free zone, you can, if you're importing in. As far as the mainland is concerned, so whoever will be responsible, setting aside the customs duty exemption, suspension or the exemption, in the free zone, it will be the responsibility wholly and solely for the importer of record, whoever has registered his business under his own trade, trade license and everything. As far as mainland is concerned, in the mainland, if we are, you can say, transiting out the goods from the free zone to the mainland. So then in the mainland, it will be the relevant importer of record, whoever has registered business in the mainland area, and whoever is, having a trade license from the ministry, because it will be for the local market. And at that time, the customs duty will trigger. So this is what we have, the basic constellation. If you want to add on, Thomas.
I don't want to steal your limelight, Atiya. So I don't know. Let's maybe. I guess these are the principles and whatnot.
Yes.
And I think what the reality was that some wanted to understand is, is there a way or not to still deal with mainland businesses? But yeah, if happy to close off, or if you have any concluding statements, otherwise we can go to P3 for lunch.
Any further questions? Otherwise, we can. Yes, you have a question?
One of the things which happens in UAE is it's also trade license based. A free zone company can open a local branch and then enjoy the local market privileges as well. That's also a nuisance that happens in this market, which is very unique over here. So a company having just one registration doesn't have to be limited to free zone only.
Yes, of course. Thanks for this. And of course, for that purpose, they need to fulfill the legal requirement for the local market as well. So once it is done, the paperwork and all thing is done. So of course, then they can have this, you can say transit in, transit out from the free zone.
The same company can also be the import on record by using the branch license as a custom code holder of the import on record.
No, this is something which, to be honest, it's a kind of area where it's you can say it's a gray area, which we can say. So thank you so much, all of you. It was quite interesting speaking with all of you instead of speaking with my students back in the university. And yeah, it's thank you so much again, Thomas, for having me here. And it's a pleasure to see all of you, speak with all of you. Have a lovely day. Thank you.
All right, good afternoon. I hope everybody had a great lunch. It's a pleasure to be introducing David Paya. David and I met a couple of years ago through his wife. David's been in compliance his whole life, knows the topic in and out. And what I always appreciate with David, as well as his frankness and his willingness to give his own standpoint and opinion. I think for the UAE, as a country being relatively neutral in what is an enduring conflict and being a territory, I think you have air quotes between neutral next to the word neutral in your presentation. A lot of the business has shifted to the UAE as more neutral territory, whether it's Chinese or Russian or American for that matter, and providing sometimes a central point or a secondary way of organizing your operations. So I think we'll hear from the bank side of things. People always get frustrated. How come I can't open my bank account? How come it always takes so long? Well, this man is to blame. So without further ado, I'll hand it over to you.
Thanks for this very warm welcome. Thomas, yes, my name is David. I am very blunt. That is due to my culture. I'm Dutch, so we don't know of any other way to express ourselves. So I'll just give you the real version of how the compliance is looked at in the Middle East. To make it a bit topical is something that you can read every day in the newspaper, because what's happening in the world, conflicts, geopolitics have a ripple effect on the UAE first and foremost as a place that is always open for business. And how does that reflect changes in what's happening in the world? How does that reflect, for instance, banking, something that I've been working in for 22 plus years or so, and once you get into compliance, there's no way out. I tried several times, but it's mostly no one will accept you anywhere else. So I'm head of compliance with the local Emirati bank. And just to stress out, I'm doing this presentation on personal title, also because I have an opinion, and sometimes when you're head of compliance and you express an opinion that is a bit, direct, does not always get appreciated. So what I will do, I will give you a few, facts, things that are currently happening, and how does that impact what we do. I was given to understand that most of you work in tax and customs, so there might be some overlap here or there. And yeah, to open a bank account or having issues with that is one of the problems that we all face. Just to give you an example, I got actually kicked out of my own bank back in the Netherlands because I live in a high-risk country. And the irony of that is, that was actually the bank called ABN AMRO. Doesn't matter. It's a big bank, used to be a big bank. And it was done on the basis of a policy that I wrote back in 2005 that still applied. So, compliance at the end, it's like a dog trying to bite its own tail. You get confronted with it when you least expect. Anyhow, so there is a big, a big issue nowadays. I know people have been complaining about it, but I just wanted to dedicate some time to this, because I've kind of looked into this topic in a little bit more detail. I understand that one of the next sessions will be given by lawyers who will focus more about sanctions and the regulatory landscape. That's basically what the law says. So I will not, steal too much of their thunder. What I will focus on is more, how does it actually work in practice? Because we can read the law, we can see, what is allowed, what is not allowed, what is exempted, and so on. But is, maybe interesting from a compliance perspective, how does that actually impact, what we do? Opening a bank account is just one thing, but just trying to do a transaction with a counterparty that may happen to be Russian, do banks still allow that to happen, and I will give you a bit of a mixed outcome there. So, yeah, the title I put is, to which extent has this invasion by Russia of Ukraine affected risk appetites of banks? And with risk appetites, I mean, the willingness to still do business with, a country that is as big as Russia, and how to control that if the answer is, no, because there are clearly a lot of sanctions issued by mostly the West, Europe, US, UK, Australia, Canada. Not so much the United Nations, obviously, because Russia is a permanent member of that, and they have a veto right to do so. So it would be very strange to see if there would be UN resolution to sanction Russia. Would not make any sense. So just a bit of facts on what happened in the past couple of years. You may also have noticed, if you live in Dubai and maybe one of the northern Emirates like Ras Al Khaimah, composition of some of the population has kind of changed as well. And we have, if you focus on the conflict, it's been out there for about 2 years now. Yeah, 2 years almost. And sanctions have been placed on mostly Western companies doing business with Russia in specific sections. So sections Russia is very well known for, and strong in, like, commodities, oil, mostly in the oil section. But in the meantime, fast forward 2 years, there have been, a number of changes there where the scope of those sanctions has been considerably broadened, to the point that the Americans are trying to also apply those sanctions extraterritorially. So it even means that if you don't have a nexus with the US, you can, as a bank in the Middle East, you can still be placed on a sanctions list by the Americans, if they suspect you to inadvertently or do business with Russia under the radar, meaning not overtly, but maybe through third parties, through different jurisdictions, and you haven't taken enough measures to prevent that. I think that's the biggest risk for banks overall here in the UAE, because, as I said in the beginning, we're open for business. We want to be trying to be friends with everyone and trying to establish, a climate, a place where business can thrive. Now, if you look at this demographically, because of the conflict, we've had quite an inflow of people coming from Russia for several reasons. And with that, they've brought in a lot of capital as well. We've seen an inflow of a lot of wealthy Russians. And, wealth to the point that it's cannot always be explained how that wealth was earned, which is, one of the main things in compliance to ask once you open an account. How have you earned your money, with which activities and where? And I can tell you based on practice that that's more difficult, to get those answers than it seems. So we had about 2 million Russians visiting the UAE. That's a huge number. And it's estimated that of that, about 10% or so has remained in the UAE. It means about 200,000 Russians are on top of the existing population in the UAE. It doesn't mean necessarily Dubai, but also a place like Ras Al Khaimah have kind of grown exponentially as a result. And everyone who comes, this is more of a transitory place. As an expat, I know I've been here for about 12 years, but the population of Dutch is considerably smaller than what we're talking about now. But people that come to this place all need to live somewhere. They need to open bank accounts, or utilities and so on. And this is also partially explaining, in my opinion, why the real estate market is so booming. Now, while it's not only Russians, there's also a lot of other nationalities, India, UK, that have in the past couple of years bought a lot of real estate, and as a result of which we can't keep up even when building very fast. Real estate prices have boomed, which I personally believe is an untenable situation. It has to flatten out at some point, but we are not seeing the end of that yet. I just renewed my rent. It went up 40%. So just to give you an example. Now, the question is for compliance people, ways, how can you prove the source of wealth? How can you prove the source of funds? Specifically, as you know, many US sanctions on Russia have basically prohibited banks to transact with any Russian bank. I think that about 80 to 90% of Russian banks that transacts through SWIFT, which is the international transacting, let's call it system, the main system through which wire transfers go, has been taken off SWIFT. So even if you wanted to, you can't transact through SWIFT. But there's a few banks remaining that still have access to SWIFT. So it's definitely has provided the UAE, with a kind of a boom in its economy. But question is it something that will hold on for a longer time, or whether it's gonna flatten out. A few of the numbers that I put here, you can also see that there's a lot of money that has flown into other sub-jurisdictions of the UAE. As you know, we have a whole system of free zones, which actually makes it easy for anyone to establish him or herself. I mean, in an overly pessimistic scenario, you could say that even if I'm a non-resident in practice. I need to be in the UAE only 2 days a year in order to get my Emirates ID, once per half year. And the other 363 days, I don't have to be here at all. I can be in Russia, I can be in Iran, I can be in any place from which to operate. That's why nowadays banks are very picky and very, on the verge of, irritatingly asking, so many questions. They will even monitor IP addresses, where prospective customers are asking are from where they are sending their emails, and to just establish where they actually are. On paper, anyone can be in the UAE, but if you set up a free zone in a few days, I can do that as well, and then just work from Europe. No one would know. The golden visa regime, for instance, if you just, that has been broadened lately. It has been broadened for a few years now, and many people are eligible to get it. Doesn't mean that they really have to be in the UAE, once in 6 months. So that makes it very difficult to perform due diligence, all of these things. And the fact that I highlighted Russia doesn't mean that many banks have a no Russians policy, but it's just to kind of show the dilemma we are in, because you're kind of stuck. Here in the Middle East, wanting to be neutral, you get stuck between a rock and a hard place. And I will explain that a little bit more. These are just numbers to indicate how much money has been attracted from, regions, not only Russia, to be honest, former Soviet Union states. Generally, we want to be open to both Russian and Ukrainian nationals alike. There are big communities living here, and we want them all, to feel happy here. Now, I wanted to focus a little bit also on, what the bank's stance is, because we are kind of in a split. I work for a small niche bank, a small Emirati bank that has no branches or subsidiaries outside the UAE. So that makes it fairly straightforward for us. But if you are in a bank that has, branches and subsidiaries outside, for instance, in the US or in the European Union, the problem with compliance is that sometimes you're damned if you do and you're damned if you don't. If you comply with one regulation, you might be breaching that, another, in another jurisdiction, that might constitute a breach. We've also seen that with the sanctions on Cuba for a long time. In the European Union, dealing with Cuba was a very normal thing, but if you would dollarize your transaction, it would go through the US financial system, and then the Americans would, freeze that payment. Same thing for a long time, until a few years ago, we had the Arab boycott on Israel. For decades, that boycott had been lifted. Now we can freely transact with one another. But during the boycott times, if you would comply with one regulation, you would breach, the same from a different jurisdiction perspective. The Americans had an anti-boycott regulation. So if you are a bank in both, the Middle East and in the US, again, you can't comply with both at the same time. So that was a big issue. Now, what I've seen here is more of a, everyone can understand, how sanctions work. You have embargoes, comprehensive sanctions. You have targeted sanctions on individuals or entities, or you have sectorial sanctions. And that's happened with Russia. I think Russia has now overtaken Iran in terms of, depth and breadth of, what is no longer allowed. First of all, it started with 2014 with taking of Crimea, which the West reacted to that by issuing sectorial sanctions, which meant that any business with Crimea would from that moment on be, sanctioned. But that was very minor, because that related to money market transactions and capital market transactions. So if there were just normal payments going on, that would not be in scope. Nowadays, it's become full-fledged, prohibition to most of the banks. And what does it mean if you are here in this country, having a Russian nationality, wanting to do business with your home countries? What does it mean when you want to open a bank account? Now, I happen to be part of the UAE Banks Federation, which gathers, and all the heads of compliance, they share ideas and worries and conflicts, and it's also a nice forum to benchmark what's happening in the market. So I did a little bit of a benchmark to see how banks interpret this, because there may be a lot of sanctions in doing business with such a big country like Russia, but in the UAE there are none. So strictly, legally speaking, there's no prohibition to transact dirham or Russian ruble. But in practice, it's more complicated than that, because if you are a bank that's doing international trade, and for international trade you use the reserve currency of the world being US dollar, a lot of that will get dollarized. From the moment on that it hits a US bank, they will start asking questions. If the party in the payment appears to be Russian or has control, is controlled by Russian entity or UBO, ultimate beneficial owner. So there's a lot of banks that are kind of grappling with this, including the bank where I work. And I've put kind of a bit of different colors around it to exemplify that that's not very clear cut. On the one hand, I spoke with compliance people that worked for banks here in the GCC, in a different country, that just said, you know what, we're a small bank. We don't have too many compliance people. It will lead to additional cost to do this full and enhanced due diligence. We just prohibit any Russian to come in and open a bank account, which is, very far. It's quite stringent. But it's a reality nowadays. There are also banks, existing ones, larger ones in the UAE, that continue to easily do foreign currency transactions also on Russia, and to the point that I believe that they are at risk, because all of these payments will need to be explained. They can be placed on hold through the correspondent banking system, either in Europe by a European bank or an American bank. And chances are likely that that payment may not even be returned, simply because there is a match with the sanctions designated entity or individual. But some of the banks here, they have the market power to do that. I work with a small bank that does not. So we are somewhere here in the middle, probably the yellow part. So we adhere to all these sanctions, but mostly in order to mitigate those risks, we allow dirham transactions only. That means that some of the transactions that may be perfectly legal, we still don't do them, simply because of the correspondent banking risk, because there are correspondent banks that still ask each year to ask us as their respondent bank, do you bank people that are sanction designated on those questionnaires? And if we say, yes, we do, we have more to explain, which is an area we don't want to go. Because the risk of that is that they don't like the answer, and they'll just cut our SWIFT keys. And then we are out of business as a bank, and no longer matters whether you're in compliance or whether you're in the commercial part of the bank, and a relationship manager, and then we can all find new jobs elsewhere. So that's this is a big risk for us in the UAE to kind of survive and try to navigate those sanctions. On the one hand, I believe it's too far-fetched to be so stringent to just block a nationality from getting onboarded. You still need to do some sort of risk assessment. I'm going to give you some examples, some FAQs that make it a little bit more tangible for you how this impacts what we see in the financial sector. Like a few questions I wrote down here because I've received them many times, and you may recognize some of those. If I have a company in the UAE, can I still do business with Russia? Now, the correct answer to that is it depends. It's a bit of a lawyerish answer. It depends on all facts and circumstances. Obviously, currency is one thing. If you mitigate your transactions to dirham only, legally speaking, for instance, if you don't dollarize it and you don't put an American bank into the clearing of the payment, there are no US elements involved in that transaction. So the US regulator cannot assert jurisdiction over it. So that's how many banks do that. I think it's a pretty common practice. It becomes murky where some of those practices can be seen by the American regulator as evading or avoiding. I've also had requests of late by our bankers saying, look, we have an existing customer who manufactures goods in Russia. We have an AED account still with them. But they are mindful that they cannot transact in US dollars. So they ask, can we open a Chinese yuan account? Which is not very common. But clearly the context of that was very clear that they try to get around the American sanctions and try to, get their manufacturer paid in a different currency. That in itself, getting paid in a different currency does not have to be a problem, but if it relates to certain industry, like oil and gas or petrochemical industries or specific sections that have been mentioned in one of the executive orders by the US Department of Treasury, even fish nowadays is problematic to be imported into Europe or into the US. Vodka, fish, all the things Russia is great at can no longer be imported. And that's clearly to kind of cut off the income stream to finance the war. So you can still do business. The answer to the question is I can still do business with Russia, but it depends on the currency and it depends on the industry I want to finance. And also if there are any sanctions listed banks are involved in the payment chain. If the answer is yes, then obviously the payment cannot be made. Unfortunately, each and every bank nowadays has filters and payment filters that pick up whether there are blacklisted entities involved in the payment chain. So if that's the case, the payment cannot be made because it gets stuck. The filter will red flag it, and then the payment cannot be executed. I've also had a question on, we probably have already answered that, large number of manufacturers of goods. They are still located in Russia. Can I pay them? What would you say? It's a bit of a, it depends again on what kind of goods they are. There's still big European companies. Some of them have totally wound down their business in Russia. Others have more difficulties doing it, and they have, also difficulties to get paid as a result of the whole embargo. It depends also on the currency and on what kind of goods those are. Another question is, do we open bank accounts for Russian companies? Are any of you working with Russian counterparties? What if there's a Russian law firm that has, let's say, a tax advisory that has a branch in Dubai advising Russian clients? Can we open bank accounts for them? No one knows. I mean, what would your gut feel say? I mean, lawyers are just like normal people. It's a yes. Why? It makes sense to open bank account for lawyers. Well, yeah, they have to get paid, right? One of the most important thing to write your invoice and get paid immediately. Of course, yeah, it depends on whether that law firm is, sanctions designated or not. Most of them are not. And most of them are actually, even if they would represent clients that are sanctions designated. It depends from bank to bank whether they would process that payment or not. But typically, if you are a law firm and you represent someone who is on the blacklist, let's say he is going to litigate to get himself off the blacklist, that client needs to pay you. Right? You're not doing your work out of the goodness of your heart alone. So in those cases, for instance, if you look at it from the American perspective, even those kind of payments, they can be exempted, but you need to get a special license for that by the Office of Foreign Asset Control, which is a part of the US Treasury, which is an arduous process altogether. But once you get the license and you represent more of these people, it becomes easier. The only problem then is you need to find banks that are still willing to process it. But because not each and every bank wishes to process it, even though it's legal, because their risk appetite goes beyond what is strictly prohibited. It becomes kind of a jigsaw puzzle to know how you have to route your payment. And, it's just an intrinsic part nowadays of compliance to figure out whether payments that we believe are within our risk appetite are actually also within the risk appetite of our correspondent banks. I think the key question to solving all that lies with the correspondent banks. They have the market power to impose some of their policies upon the smaller players like ourselves here in the UAE. Because imagine that if they'll just delete all the correspondent banking keys with UAE banks, the UAE would be done as a hub that is open for business. Now, that's basically also the last question. If I provide legal tax advice to Russian clients, what do I do? Is this even possible? Well, yeah, the answer is yes. In the UAE, there are no prohibitions. There are no prohibitions whatsoever on doing business with Russia, but it can get you in a lot of trouble with the US. I'm not sure how much you know about sanctions, but I think it was on the 22nd or the 23rd of December of last year that there was another executive order signed by US Treasury. And why do we actually look at that? Simply because it is power politics by the Americans wrapped up in legislation, and we can't ignore it, because if we do ignore it, they will kick you out of the US financial system. And once you're out of the US financial system, you are done as a financial institutions. So whether we like it or not, whether we agree to foreign policies or not, it's not to be ignored, and that's why we study those regulations. Now, that regulation states, if we believe that you, as a non-financial or non-US bank, are doing business below the radar with Russia, then we can blacklist you. And if you're blacklisted, one of the measures we can take is to cut you off the financial system. That was already possible under the Iranian sanctions. There's a law called Patriot Act, Section 311. If they place you on that list, you are going to be seen as a bank of money laundering concern. So they use that specific provision to kick you out of the financial system. This is very stringent because there is no jurisdiction whatsoever there. You don't even have to transact dollars. If, for instance, the Emirati bank where I work transacts dirham with a company that is established in the UAE but has Russian UBOs. Okay, they have owners located in Russia, and those UBOs are seen to be part of the inner circle of, let's say, Mr. Putin and the top politicians. The US regulator can put the Emirati bank on a list to further scrutinize those transactions. And once it has not become unequivocally clear that they've done enough to be part of that sanctions facilitation, then they get listed. So what we are currently doing, and Russia is quite a big country. It used to be, Soviet Union, 15 states, if I'm not mistaken. So it has about 14 neighboring countries. What we have done, my teams, they have picked all the transactions before, let's say a year before 2022, or the 24th of February 2022, and after the 24th of February 2022, all the transactions with all the neighboring countries of Russia, to see if there is a spike in volumes after the 24th of February, because a spike in volumes may indicate abnormal, let's say, may prove indications of sanctions evasion. So there were a few countries that gave those increases, that showed those increases. So we focused on our customers. We dug out a list of customers who were dealing with those countries to see whether it in any way tried to do Russian business without disclosing it on the basis of invoices, contracts, and just payments. Now, fortunately for us, we didn't find anything that was really meaningful, but this is the level of due diligence nowadays that is expected, and it kind of is problematic now for any type of customer who wants to deal with any of the neighboring countries of Russia, because very likely, whichever bank you use to wire your transactions to, it will lead to delays in payment. And that can be also vital, you lose a contract as a result. One other problem that I see, how do we deal with prior contracts? Contracts that were concluded for a longer term, that were concluded, let's say, in 2021 with some of these companies. When you conclude a contract, it creates payment obligations that cannot be ignored. Or can they? If you don't repay your counterparties, you may get sued in court for it, for non-performance. So that definitely constitutes a legal risk. However, if you pay, if you conclude a contract in 2021, your counterparty gets sanctioned after February 2022, and you need to make a payment, what do? That's not clear cut. Sometimes, in order to honor a contract, you might consider paying or changing a currency to not, to still comply, but not breach with the sanctions. Could be. But even that could also be problematic, depending on the routing of your transaction. So it's just a bit of background on how this kind of impacts daily practice. I'm sure what is now very topical, maybe for me to mention, what we're seeing from the Central Bank of the UAE, that they have reinvigorated interest in beefing up what they call proliferation finance. Not sure if you are familiar with this term. So first we had money laundering, then we got terrorist financing as part of the same duty to prevent it as a financial institution. Now there's a third leg to that called proliferation financing. So now banks like ourselves, we have an obligation to figure out on the basis of documentation and the payments, whether those payments serve to facilitate the creation of weapons of mass destruction. So if I issue an LC or advise an LC for the export of certain goods that, let's say, tubes or certain, technology that is somehow sophisticated, there is now an obligation on people in the bank, in compliance, to figure out whether that underlying technology could potentially be of dual use. Now, these lists are created by an executive office in the UAE that makes a whole list of these dual use goods, and we need to screen those. If they hit the filter, we need to further analyze whether they could potentially be dual use. The problem with dual use goods is that whomever creates those goods does not want those goods to end up in a non-friendly place. So the Americans have a whole list of dual-use goods. The Europeans have a list of dual-use goods, and even the UAE has a list of dual-use goods. They cannot end up be used for restricted end use to make a bomb, for instance, with a restricted end user. So there's a lot of countries where we don't want, for instance, certain goods to go to, like China. China, not per definition, is a sanctioned country. But from an export control perspective and dual-use goods perspective, we just don't want to export certain goods to China because it could be used in a different way. The exporter needs to obtain a license before he can export those goods. But those documents need to also mention the end user. Sometimes what we've seen in compliance practice is that even that gets falsified because we have an existing customer who wants to maybe do business with North Korea. But the goods state that the end use will be somewhere in a border town, somewhere in China, in a border town with North Korea. So we have all kinds of red flags nowadays that are given by the UAE that we need to filter against and that we need to scrutinize against. So basically, half of my team, they have become physicists and chemists to understand what this is for. And we actually have had cases back in Europe when I started to kind of get into this area, new area of compliance that can be quite technical. People have been convicted for, and banks have been fined for facilitating this. There was an important case involving a Dutch guy. Obviously, I take particular interest in what Dutch people do. They always want to make money. They're very, they're business people. Someone who was exporting an underlying good, which is called thiodiclycol, which in normal use can also be interpreted as mustard gas. Thiodiclycol you can also use as a substance to make pens to write. He exported those goods via Antwerp, Belgium, to Jordan, where supposedly on the basis of the trade documentation, the end user was a Jordanian company. However, there were some red flags that were ignored also by the bank that should have indicated that those goods were actually going to Iraq. And we are talking about Iraq before 2003, when there was still, Saddam Hussein was still reigning with an iron fist. That guy got a prison sentence of 9 years because he knew or should have known that exporting this would end up at the Iraqi regime to be used to gas thousands of people. So it's become quite serious business, and I'm not sure how I can instruct my people in compliance, how to understand whether this is going to be a pen or it's going to be mustard gas. In my personal opinion, these are regulations that are not feasible to operationalize simply because there is no knowledge with simple bankers or simple compliance people to actually understand this. The simplest way of resolving it is like the Americans do, what the Americans do. I normally don't really agree with a lot of what the Americans say, but they keep a very simple way of scrutinizing it. Just put companies and individuals that are expected to export these type of goods on the blacklist, and you can screen against those. You can't screen against the underlying goods. On top of that, when you do so, you will pollute your filters because it will create all kinds of false positives that you need to, you need to discard. There's a lot of extra work for us in compliance, and when I see legislation, I think this is not workable, I always start doubting myself. Maybe I'm wrong, right? So I have a good friend who has a PhD in biochemistry. So I showed him the European lists with all these goods. I said, can you make anything out of this? He said, what is this? I don't understand what this is. I said, you have a PhD in biochemistry. There's a whole section of biochemistry. He says, I don't know what this means. So if he doesn't know what it means, and he studied for it long and hard, how do simple compliance people know what to do? So This is also part of sanctions. So sanctions are a great deterrent. Sometimes they work. Most of the time they don't. Let's be honest about it. Because if sanctions are imposed unilaterally just by a few, it will always lead to, ways of getting around the system. And that's what's currently happening in the UAE. The UAE is known to be a pass-through for these type of transactions simply because it's very convenient. We're easy for business. You can set up your company easily, no questions asked. Unfortunately, while we have come a long way in banks, compliance has improved a lot. With any type of financial criminals, they will try to find the way where the place where the controls are the easiest to get around, and that's what's currently happening. It's getting harder. It's getting harder. Also because, Americans are cracking down on this. I had a call 2 weeks ago with the US Department of Treasury, and they were kind of pushing all the UAE banks to do more, to avoid sanctions, to do more on spotting sanctions evasion and sanctions avoidance. Now, it's kind of an impossible task because, to be honest, to be able to turn around all the work that we get, I need to double my team. But obviously, my boss, who is the CEO, he says, "You cost money. You're a fee burner. You're not a fee earner. Why are you asking me this? Bank is not making enough money to do this." So it's always, a problem. But on the positive side of this, if we wouldn't have this, we wouldn't have a job. So at the end, it's one big conflict of interest to be in compliance. Anyhow, if you have any questions on how it works in the financial system, I'll be happy to answer them. Can we still send any payment to Russia? Can I still, I have family in Kazakhstan. Can I still send them dirhams? Yes, you can. So I think that's it in a nutshell. I know it's quite different from taxes, but I study taxes as well, but more from the perspective, how can they be misused? And here's hoping that, I'm not sure whether you agree with me, Thomas, but we will see the day that even salaried people will get taxed at some point. Maybe it's like, indicating the maturity of a country where, the different kind of taxes are being, invented. We were all screaming here in 2017 when VAT was launched. I think, that's already 7 years ago. 6 years ago. Now it's become the most normal thing. Don't even look at it anymore. But taxes can be, cooked up, manipulated, under invoicing, over invoicing. For me, it's just another new leg to how can I launder money? And especially in trade finance transactions, criminals love to pay tax, and they love to pay their invoices. So from that perspective, I'm all very happy. Are there any questions on this? Or maybe anyone who wants to speak up, who maybe has a Russian nationality, who has had any issues with banks? I don't want to put you on the spot, but
I'll give you the opening question, maybe, David. Obviously, not a Russian national. But continuing with that reference, if you are the head of compliance in a bank, and not sure if you know this person, obviously not personally, but there's a person who they refer to as Putin's wallet, the guy who holds Putin's money, for example. And it leads me a bit to some structures which are sometimes used in the UAE to dissimulate who is the actual ultimate beneficial owner of funds. And I ask myself, you must have a hell of a task trying to figure out who is the ultimate beneficial owner of certain structures, or who is the real person that holds that money. And I'll give you an example. When 22nd of February 2022, what we saw, for example, just anecdotally, is I went to the playground below our house, and there was a Russian family there, and they had just picked up their bags, and they came, and they said, "Yeah, we're not able to open a bank account. Someone else has done it for us, So we've given that person money. So that other person was actually trying to do a good deed for these people because he said otherwise, you know, how can they function and operate? So I guess how do you distinguish that? Maybe that's $1 million question for you.
It's a very good question and it's very pertinent. Let me just give my own flavor to this. So you have normal Russians coming here because they're just sick and tired of the conflict and you know, just wanting to be in a safer place. But you also have those ones that are high profile, as we call it in Russian, vari v zakonie, those ones that actually have a you know, are in a criminal circle that are kind of, you know, left on their own device when it was, you know, still after the Soviet Union imploded in 1991. They started their own empires, and now they have made so much money that they have to kind of safeguard that money. Now, this is in personal title anyhow, so not that it matters when people really have issues with it, but I'll tell you an example what I faced 2022, mid-2022 with my bank. The bank where I work is held by or partially held by the Emirate of Ras Al Khaimah, the most northern emirate, and they seem to be in very good standing with some of the Russian elites. One of those Russian elites, I think it was the eighth richest man in Russia. He had a couple of yachts, the ones that he managed to escape with from European waters because they're all now chained in Europe. But one he managed to escape with, it was one of the smallest yachts. It was only 300 meters or something like that. That is now docked in Ras Al Khaimah. And he apparently has so much money. He married a Serbian photo model / rock star who happens to have the same initials. And that's relevant because I'll tell you that story later. So he was pushed by one of our board members in the Emirati Bank, who actually represents the Emirate of Ras Al Khaimah. So he had a direct line with the ruler of Ras Al Khaimah, who was big buddies with this Russian individual. So much so that he received the UAE nationality within 9 days, next to his own nationality. So money talks, right? Now, Ras Al Khaimah has big plans also to diversify its economy, to set up a gaming industry, and even some sort of you know, betting industry, casinos and all that, which used to be haram, but not anymore, apparently. So of course, they can.
Yeah, Andres Iniesta.
They can.
He scored a goal that it was a World Cup for Spain.
Yeah, we hate him for it in the Netherlands. If I come across this guy, he's smaller than me, so I can have. So, long story short, so this person, highly influential, was referred to a board member. And I tried to push back on it. No, we're not going to onboard this individual because it was clear that he had, you know, huge power, a lot of money, and also, yes, the problem was wasta with the ruler. So I pushed back on it, saying, let's not do it. He had already been placed on a European Union blacklist or on an American blacklist, but not yet on the European Union one of those. And I got overruled, and that doesn't happen very often. If the head of compliance gets overruled, there must be, you know, a lot at stake, a lot of money. So I said, okay, it's all in the game. You want to overrule me? You're the board, so you are entitled to. I'll make a memo. I write this down now for you. Hereby, board member so and so, I accept the risk onboarding this particular individual. Please sign. I waited for about a month. They didn't want to sign it. I said, look, this is how the governance works. You can accept the risk, no problem. But, you know, I advised you against it in my capacity of head. You shouldn't be onboarding this. After 1 month, back and forth, they said, okay, David, you're not happy with it. Maybe we should wind down whatever we have opened with him in terms of accounts. And by the way, they had given him a credit card with a 1 million dirham credit line, which I was not aware of. And on that credit card was embossed only with the initials, his initials, which happened to also be exactly the same initials as his wife has, the initials that his wife has. So it could be interchanged between them and no one would notice. Now, you can be sanctioned, which means that you can no longer do wire transfers online or between banks. But if you still have a credit card, you can do any purchase online. It's the same thing. So we try to, we blocked that credit card at some point, and then he sent some of his people over to the branch physically. Now, I'm not sure whether you've ever done business with Russians. It's a different league. Our head banker got bullied so much. I tried to actually, put it on camera. It was that bad. So I spoke to my boss, who is CEO. I said, Ali, if you, irrespective of what risk they are, you don't want to be banking these people if they treat your own people like this. I've never seen this before in my life. So it took a lot of time to actually get them, to relinquish whatever they had to get rid of the exposure, because we got stuck with it. I mean, if he has a credit card limit, which he uses on a daily basis up to 1 million, that's still serious money. So at the end, we were able to do that, and one of our board members had to go back to the ruler to explain why we closed the account a few months after we had opened it, which is not a good look. So it was actually kind of lessons learned to some of the people in the board, including my boss, that, be very careful, and basically why you were mentioning an inner circle and, structure of companies that lead to one, elite person. Normally this person never shows up, but they send either their general counsel or they send, one of their, their helpers, помощники, as you say, помощники in Russian. And it was an interesting experience. It's very difficult. We have all kinds of intelligence nowadays in the bank that can unravel all these companies, also how they link to one another in different jurisdictions. And it's very sophisticated. Sometimes we figure this out, sometimes we don't. But that's the expectation nowadays, enhanced due diligence. Banks have been fined for not doing this. If we hadn't done enhanced due diligence, we would not have figured this out, because the man had not been sanctioned yet. Funny thing was that when we were already in the process of exiting him, he got sanctioned as well. So that was another reason to accelerate the exit. Any other questions? Okay. Thanks so much for your attention. Thanks.
Right. Thank you so much, David, again, for this. Much appreciated. Our next panel is going to look at, I think, what David implicitly referred to as the boring bit, which is, as I said this morning, the battle of the beasts. So I'd like to get on stage Bert, Vladimir, David, and Paco as well. Francisco, please, to come and take a seat. Each of you who are going to speak, and I think the first one is going to be David on US issues. Each of you can stand here or sit down and use the clicker. So I guess we're going to be hearing a couple of the legal sides more, please. And Francisco is going to be the moderator.
Thank you. Thank you very much.
Either click or you can stand here.
Good afternoon to all. We're going to try to speak louder, so we will not be able to let you sleep. after lunchtime. So we have a hot topic today, which is basically economic sanctions under the international trade of goods point of view. We have heard the financial controls for international sanctions, and now we're going to check under the international trade and customs measures and tools that we have or we have to implement in order to following the sanctions imposed not only against Russia, but against different countries, depending upon the focus of each of the, let's say, the blocs, European Union, the US, the rest of the world are engaging in this regard. So what we have here in this panel, we have David Stepp from Crowell and Mooring. He's going to give us the United States view. We have Bert Gebers from Loyens and Loew, which is going to help us with the European Union point of view. And our dear friend, Vladimir Chikine. I don't want to pronounce properly because it sounds chicken. Yeah, I knew that, but I did on purpose. I hope you don't chicken when you talk about the Russian view. So having said that, I give the floor to David. David, please.
Thank you, Paco. I'm going to stand up here. What? So it's great to be here today and to see everyone. And thank you, Thomas, our wonderful host. He's done a great job in compiling this panel that we have here today. So I'm going to provide a few comments on the U.S. perspective. And I'll first mention that David, our previous panelist, did a great job in providing a wonderful summary of the practicalities of the U.S. sanctions and export control laws. I'm primarily a customs attorney focusing on the import and movement of physical goods into the country, so that will be my focus. Although I'll talk a bit about some of these other things, other sanctions that are in place against Russia, China, and other countries that are being targeted. So these are some of the topics I'll cover, but I'll dive into it because I know we're getting shorter on time than we'd expected. I'm going to first talk about inbound and outbound investment. There is the Committee on Foreign Investment in the U.S. CFIUS is the acronym that's used. And this agency over at the Treasury Department, U.S. Treasury Department, that's an interagency committee looking at investments into the U.S. And increasingly, CFIUS is having a bigger voice in the U.S., primarily focusing on investments in U.S. businesses and real estate by foreign companies. Increasingly, China has been a target of CFIUS as China increases its investments into the U.S. and in critical industries. And also a focus on the transfer of technology because certain investments are going to be blocked if there is the chance that that technology is going to be compromised or perhaps flow back to China, and that's against the U.S. interest. I'll give you an example or two. We've seen investments blocked by Chinese investors of facilities and real estate that are close to government facilities, for example, military bases, other similar sorts of places of national security. Another very interesting one is a dating app in the U.S. Was owned by the Chinese, and CFIUS required that the Chinese divest from that dating app because, as you can imagine, if there is a U.S. congressman on the dating site and perhaps shares a revealing photograph or other information that could be, a concern from a national security standpoint. So this sort of issue has become quite prevalent as we move forward. Just very briefly, there's a new executive order that was issued by the administration, the Biden administration, about outbound investment. this new national security program will require reporting of certain transactions involving investment outside the US. And in fact, in certain situations, there will be actual prohibitions. This is very early on, lots of regulations and other administrative guidelines to be issued soon regarding that, but certainly a new sort of policy for the US. Again, I'm not going to talk a lot about sanctions on individuals and entities, as David did a great job here, but focusing on the Office of Foreign Asset Controls at the US Treasury Department. There are specially designated nationals, SDNs, certainly a lot of Chinese on that list, Russians, North Koreans, some of the hotspots around the world, at least from a US perspective. Some notable recent sanctions against Chinese individuals and entities that are helping to compromise the Hong Kong autonomy issue, human rights designations. I'm going to talk a moment about the Uyghur Forced Labor Prevention Act, the UFLPA. There are designated companies that have been identified as furthering the abuse of the Uyghur, the alleged workers being compromised in the Xinjiang region of China. Also, Chinese individuals helping to facilitate the Russian invasion of Ukraine, and also certain entities that are involved in the fentanyl trafficking situation. Also, very briefly about export controls. I know Bert, my colleague, is going to maybe talk about this from the EU side, and David previously talked about that, but significantly increased efforts in the US to control the flow of goods from technology, military arms exports from the US, whether directly or indirectly. Starting in 2018 to 2021, ZTE, Huawei, more recently in 2022, 2023, focusing on the semiconductor industry. There's a huge push in the US to restrict the export and the technology flow to China for the production of semiconductors, very much a competitive sort of measure. And then more recently, focusing on the Russia situation in Ukraine, as well as additional restrictions on Chinese activities. One of the things, and I'll just mention as far as context goes, up until 2016, my entire career has been focused or has been observing the expansion of world trade. It really, the WTO, China's admission into the WTO, tariffs going down around the world, multilateral, bilateral agreements. And then in 2016, there was like this halting stop with the new Trump administration at the time. And it was really the first time in my career where everything had to be reevaluated. China was certainly the target, but the multilateral trade agreements, either those negotiations stopped or we pulled out of those negotiations. And with that came initially the imposition of what are called the Section 301 tariffs, focused on China. And these tariffs were up to 25% increases or application on goods coming in from China that had the origin of China. So if you can imagine increasing tariffs by 25%, that was, huge. That's the profit margin for many companies that are importing, but more importantly, importing inputs that are then assembled in the US. So huge implications. So as those, and the US government realized, fortunately, that sometimes those parts were critical for US manufacturing operations. So there were exemptions that were initiated and instituted. But a lot of those exemptions for the products have expired, although a few are still in place. So what do companies do? Well, a lot of multinationals and other companies move their supply chains to Southeast Asia or to Mexico or to other countries where they would, then do the assembly or the final work there in those countries to change the origin from China to Vietnam or to Mexico or to Thailand. As you can imagine, there were legitimate efforts to do this, and then there were less than legitimate measures. So CBP, U.S. Customs and Border Protection, started this incredible enforcement policy and effort to root out and question the actual country of origin of goods coming in. When you're talking about 25% duties, it's quite substantial. So if the origin is incorrectly claimed at the time of customs entry, huge duty implications as well as perhaps even criminal implications. The other thing that's been really significant for purposes of the U.S. bilateral trade with China is the Uyghur Forced Labor Prevention Act. The U.S. alleges that China has had really abusive human rights policies against the Uyghurs up in the Xinjiang region of China. So this law, the UFLPA, establishes a rebuttable presumption that all goods imported from the Xinjiang region or from certain listed entities are made with forced labor in whole or in part. So if you have a machine that comes in and there's a screw in that machine that is sourced from the Xinjiang region, the entire machine is banned from import. And this is the first time it's actually an import ban. And the burden is on the importer to prove that there's no forced labor, or as we generally have been doing more recently, is proving that there is no input from the Xinjiang region. Because if there is an input from the Xinjiang region, the importer has to prove with clear and convincing evidence that there's no forced labor in the supply chain, which is really an impossible sort of standard to beat. And, you know, people, companies, importers, exporters said there's no way we're going to be able to comply with UFLPA. If what we've been doing, we've had new billions of dollars worth of detentions in the US, in the solar industry, the automotive industry, the apparel industry. One of the first things identified by US Customs is the cotton from the Xinjiang region, which is where 80% of all Chinese cotton comes from. So if a good comes in and there are allegations of forced labor, the importer has to go back and prove where the cotton fibers came from. And actually, that's easier than many other commodities because there's now some companies that can do a DNA analysis of a sample of cotton fabric to show where the cotton came from. But the same with if you have an apparel item with cotton and polyester. Polyester is made with either petroleum or with coal. Can you imagine trying to prove which oil well the petroleum came from for the manufacture of the polyester? It's practically impossible, but it's an absolute standard. And so it's having a huge disruption in trade. Quite frankly, it could be much larger than it is. I think customs is holding back and not fully put the hammer down yet, but trying to give companies some time to implement due diligence efforts. But the US Congress is really forcing CBP to be even more stringent in its enforcement measures. I'll briefly talk about Russia. Here, there are punitive tariffs on metals such as steel and aluminum. I believe Europe actually bans these imports. As you can see here, there are significant US duties on those products, which of course has a huge impact. But if you see what I've highlighted here, any trace of Russian origin aluminum, excuse me, would trigger these tariffs. I think one of the big things that I'd like to stress today is the word tracing. Tracing has become the overall goal or the overall requirement of importers coming in, importing goods into the US. You have to trace the materials for purposes of the UFLPA, the forced labor law. You have to trace the components to determine origin under the Section 301 tariffs, whether your goods qualify or not. Here in the Russia instance, for purposes of the metals, you've got to be able to trace back to all of your raw materials, including perhaps scrap. That's an impossibility as well. Certainly very difficult. So tracing and knowing your suppliers and where those goods come from, very important. Other restrictions, I believe, have been mentioned before. There's actually an import ban in the US on certain fish, I believe caviar, certain distilled spirits. So again, it's been quite onerous for some Russian goods. One of the last things I'll talk about before I hand it over to my colleague here, the trade remedy laws, anti-dumping duty and countervailing duty laws. These are laws that are put into effect to counteract the underpricing of goods in foreign markets by the foreign producers because of the way they're pricing their goods or the subsidies that they're receiving by their governments. And so these anti-dumping countervailing duties can be quite significant. They can be 20, 30, 50, 100, several 100% of the import value of goods. And as you can imagine, companies do everything they can to avoid having to pay those duties, hopefully legitimately. So what they're often doing is they're, again, looking at third countries for their production. Sometimes that brings circumvention allegations, but we're very much involved in helping companies that are being the subject of IAPA, the Enforce and Protect Act of 2015, which gives CBP specific powers to go and investigate companies that are allegedly circumventing the dumping laws and the countervailing duty laws. And these investigations are really quite extensive. But again, it's yielding a lot of extra duty and certainly penalties from importers that don't comply. So I've listed here a few of the goods that are subject to these cases. Again, all goods that are subject to dumping duties, often quite high, and the impact on the importers and the consumer can be quite extensive. So certainly complying with the trade remedy laws is a huge requirement. So I'll just finish up by saying, as I just mentioned earlier, the key thing is to know your supplier for purposes of U.S. import compliance. You need to know who your supplier is. There are a lot of databases and intelligence companies that are out there that are that you can subscribe to. It's almost become a new cottage industry in the U.S. They're using AI. The CBP, U.S. Customs is actually subscribing to some of these services, and they will actually do the vetting before you do or as you do. So if there's a company that pops up that's sourcing from the Xinjiang region or otherwise is circumventing the duties or other tariff or trade laws, they will know at the same time you do. So you cannot avoid doing this due diligence. Know your supplier. You've got to really dig into your supply chain, not just your tier 1 supplier. You've got to go to your sub-tier suppliers, which is always challenging. There are a number of blocking statutes in place, including in China, to prevent Chinese companies from complying with some of these foreign laws. So I guess the bottom line is you need to call your attorneys because we can help guide you through these efforts. And there are other consultants and screening tools and other things out there. But again, I guess the one message is you've got to do your homework to ensure that you're going to be able to get your goods into the country. And so with that, I'll turn it back over to Paco.
Thank you, David. Nice explanation. We are pretty sure that the audience will have a number of questions after that. I forgot to tell you that we're going to do a short presentation as David did. And after that, we will have a roundtable. Feel free to ask any questions to the three. Just send the question to the panel, and we'll do our possible to answer for that. So I pass the floor to Mr. Gevers.
Thank you, Paco. Also stand. Because I noticed when I did a printout of my slides that I wasn't able to read it anymore. So that's that comes with age, unfortunately. So I'll speak a bit on European trade controls. And with trade controls, we do not only speak of sanctions, as David says, we speak on all kinds of restrictions that are imposed and that affect international trades of goods and services as well. So it's like export controls, sanctions. We had all those COVID restrictions at the time whereby it was prohibited to import or to export vaccines or ingredients for vaccines at the time. There is investment restrictions, inbound, outbound investment restrictions. And there are all kinds of regulatory measures which are put in place whereby, supply chains are impacted because of forced labor restrictions. We have the deforestation regulation in the EU. And we have all kinds of proposals which are currently being discussed and which make it, as David says, that the world of trade is very different now compared to 2016 and definitely compared to 2007 or 2006 when David and I first met in China and where we had all kinds of delegations coming from the US, from the Americas, from Europe into China to explore potential investment in China because China was definitely the place to be, to have their manufacturing and to cater the Chinese market with billions of potential new clients which are there. Times have changed since then, so that is definitely true. So I'll first give you a very short introduction into EU sanctions. And in order to do that, I'll explain, let's say, the EU general legislative framework, because there's always a challenge involved with respect to EU sanctions. In the US, it's very clear. You have a legislation or you have an executive order, and then you have the OFAC or any other government institutions that will enforce it. In the EU, it's slightly more complicated because you have competences at EU level, you have competence at member state level, and then there's a question who will enforce them. Generally, it's the member states that will enforce. So which leaves us with a situation whereby we have the general principles of law in terms of sanctions, for example, but also sometimes in terms of customs law or tax law. The general principles have been agreed by the 27 EU member states. The enforcement and the interpretation of them is outsourced to the 27 member states. EU level, 27 member states, that 27 different interpretations sometimes, 27 different enforcement agencies who all have their own priorities. So things can change. Forum shopping is a thing that we unfortunately also see in terms of sanctions or export controls or any restrictions which has been imposed by the EU. So EU level, remind you, EU sanctions, like many of the EU legislation, principles are set at EU level, but enforcement is delegated and interpretation is delegated to the member states. So what kind of sanctions do we impose? Well, there's a wide variety. I will not discuss them all, but it goes from arms embargoes to travel bans to the restriction to import certain goods or to export certain goods. But then, more importantly, what is the scope of EU sanctions? When are EU sanctions important? If you do business. And then there are two ways under which they can become mandatory for you to apply EU sanctions. First, there's a direct way, because the sanctions are legally applicable to you. And then secondly, there's the indirect way, because somehow in the framework of your business, you agreed to comply. Even if there's no EU nexus, even if you're not an EU company, an EU subsidiary, if you're not an EU person, if you do not do business in the EU, sanctions can apply just because at some point during your business, you agreed with your counterparty to observe EU sanctions or US sanctions. And that's the question. And unfortunately, our speaker had to leave of the EU bank, but that's also a trigger for the application of EU or US sanctions, even if you have no nexus at all, because you're a UAE bank or you're an Indian bank, and at some point you sourced funds from the EU or the US capital markets, and you agreed that you will comply with EU or US sanctions. And that is for a bank, but it can also apply for a normal business, because you agreed with your supplier that you will observe EU, US, UK, or any other country's sanctions. That is important to know. So when does they legally become applicable to you? That's when you are a person within the territory of the EU, whether you're from Dubai or whether you're from Spain or whatever. sanctions apply as long as you are in the territory of the EU. Second, they are applying on board of any aircraft or any airplane that falls under the jurisdiction of an EU member state. So you're on Iberia, for example, the Spanish aircraft company, you're flying from Madrid to Bogota, you're sending emails because you bought the Wi-Fi package on your flight, and you're sending emails, doing a transaction which is prohibited under EU law, you fall under the jurisdictions of EU sanctions, and you might be liable for criminal sanctions. Also, any national of a member state inside or outside the territory of the EU. I'm a Belgian, I'm an EU citizen. If I'm an expat working in India and I have a residence in India, I have to comply with EU rules, despite the fact that I'm not on EU territory. And also any legal person, entity based in the territory of the EU or incorporated in the territory of the EU. It means any Belgian company, any Spanish company, any Italian company, and their branches, wherever they are located, should comply with EU sanctions. And then the last one, and that's quite a challenging one, is also any legal person, entity, or body in respect to any business done in whole or in part within the EU. So you're an UAE bank or you're an UAE company, and you decide to import or export goods from the European Union, or you make a payment into the European Union, you fall into the scope of EU sanctions. So that's, I think, the most important to remind here. And so I have established a few statements for you. And as our previous speaker said, the answer of a lawyer is often, it depends. So I ask you, what is the most accurate statement in this respect? So first one, the subsidiary of a Dutch company in India receives an order from a Russian customer for the supply of goods, which is restricted under the Russia sanctions. Without further caution or review, he can accept. And I have difficulties to read, so I'll go to the big screen. The branch of a Dutch company in India receives an order from a Russian customer for the supply of goods, which are restricted under the Russia sanctions, and can accept this without further caution. Or third one, the subsidiary of a Dutch company in India receives an order from a Russian customer for the supply of goods, which are restricted under the Russia sanctions. It cannot accept this order. Or statement 4, the subsidiary of a Dutch company in India receives an order from a Russian customer for the supply of goods which are restricted under the Russia sanctions. It can accept it subject to further review and conditions. So any ideas? Number 3? No, number 3 is not the correct one. 4, yes, I hear 4. Indeed, number 4 is the most correct one, because EU sanctions, in principle, do not apply to subsidiaries of EU companies, because a subsidiary is not incorporated under EU law. So in principle, it does not fall under the EU sanctions. So it would be able to accept it, but it has to be careful, because if there is somehow an involvement by an EU person, an expat working in the Indian subsidiary, or there is some kind of grandfathering by the EU headquarters, because they have to approve the order, or they have to, or they provide financial assistance in the framework of the order, they fall under the application of EU sanctions. So yes, it can, as a subsidiary, but it has to be careful that there is no link with the EU headquarters or with EU expats which are working there. Yes, indeed. So if the subsidiary would be a branch, it would not be possible. So typically, EU sanctions, and each EU sanction package has the same standard clauses. So this goes for the Russia sanctions, but it also goes for the Iran sanctions and any the Venezuela sanctions and any other package. And they have an anti-circumvention clause and a general exoneration clause. Anti-circumvention clause will say, okay, you will not facilitate directly or indirectly and willingly, of course, the application of the sanctions. And the general exoneration clause says that if you do not know, or you were not aware that you were violating EU sanctions, you're off the hook, which is different with US sanctions or with UK sanctions, because there you have strict liability. Whether you violate voluntarily or non-voluntarily, it doesn't make a difference. But under EU sanctions, you can be removed from your liability if you can demonstrate that you did not know and there was no reason for you to know. And so that's where due diligence comes in. That's the obligation to perform due diligence. So another exercise here with 4 statements. Statement 1, I receive an order from a new Turkish customer. There are no restrictions for trade with Turkey, so I accept and ship the goods to Turkey. If the goods which are restricted under the Russia sanctions end up in Russia, I'm protected by the exoneration clause. Statement 2, I receive an order from an Austrian distributor. There are no restrictions for trade with Austria, so I accept and ship the goods to Austria. If the goods which are restricted under the Russia sanctions end up in Russia, I'm protected by the exoneration clause. Statement 3, I receive an order from an Austrian distributor which asks me to ship the goods to Kazakhstan. There are no restrictions for trade with Kazakhstan, so I accept and I ship the goods. If the goods are restricted under the Russia sanctions, I'm protected by the exoneration clause. Statement 4, I receive an order from a long-established customer in India. This order is similar as orders he has been placing over the past decades of our client relationship. There are no restrictions for trade with India, so I accept and I ship the goods. If the goods are restricted under the Russia sanctions, I'm protected by the exoneration clause. So more answers are accurate or correct here. So I'll just a small poll from the audience here. What statement is most accurate, you believe? I think that there are 2 that really stand out. The first one is statement 2. I receive an order from an Austrian distributor. There are no restrictions for trade with Austria. I ship them. If they end up in Russia, I'm protected. Because as an exporter, you can assume that if the goods are exported from Austria, they will be monitored by the European Austrian authorities, and they will monitor whether the goods actually comply with EU sanctions. So that is, I think that is a safe position to be in. And the other one is statement 4. You receive an order from a long-established customer in India. There are no red flags here. It is a long-established customer. He orders a quantity which is, in line with previous orders. You know that he uses this in the framework of his business. So you can assume here that there is no risk of the diversion or circumvention. The other ones, you have to be careful. You need to do more due diligence. Obviously, you cannot send goods to Kazakhstan because the order comes from an Austrian company. That should be a red flag. That should be further investigated. You should mitigate the risk by additional due diligence, by perhaps inserting clauses in your contract that the Austrian distributor should guarantee that goods are not going to Russia, or other mitigating measures. And the first one is also a red flag, a new Turkish customer. Turkey has been named as one of the countries in the framework of circumvention of Russia sanctions. So you need to do more due diligence there.
We have a union custom with Turkey.
You have
And Europe have
customs union.
yes,
Oh,
a
yeah.
customs union with Turkey, so
No.
we can use the same that Austria. That they have to comply with the
Yes, but
same-
Turkey has not
The same
implemented
sanction.
the Russia
No.
sanctions. Huh? They have no sanctions in place, so you cannot depend on the same level of controls there. And then maybe, how much time do I still have, Paco?
3.5 minutes.
3.5 minutes. So I'll be short. There are more slides than this, but I think this is probably the most important. What has been the effect of the Russia sanctions, especially the Russia sanctions in Europe? I'm dealing with sanctions. It's more than 15 years. I think a lot of focus went to Iran sanctions, etc. But you know, at that time, before the recent Russia sanctions kicked in, it was very clear that with many EU operators, there was a lack of awareness. They were not aware of sanctions, and they did depend solely on the gatekeepers, namely the financial institutions, the banks, etc., to make sure that they remained compliant. But they didn't do any due diligence themselves, or almost no due diligence apart from a check on sanctions. So that is, I think, that has changed quite a lot. The second thing is that also the financial gatekeepers, so the gatekeepers, financial institutions, they have increased their efforts quite significantly, which secondly then, or subsequently, brought more awareness with the European operators. And now I told this story to someone during lunch. A Belgian bank without any links with the US or any other institutions, they send a questionnaire to a client who is involved in high-tech or the development and research on high-tech technologies. They sent a questionnaire which was solely focused on US export controls. And this Belgian company needed to respond to that. They didn't even heard of these US restrictions, but they were obliged to respond to that. They were not affected, but they needed to understand what the controls are and to respond to their bank why they are not falling under these controls. And only then the bank would process the transaction. So I think that is a big change. Due diligence has become really important. And you see that operators are now actively doing due diligence. While they beforehand depended on their financial institutions, they now actively engage. If you do business internationally, you do engage in due diligence. Criminalization, there's a proposal which is accepted by the European Union to make to impose criminal penalties and criminal sentences on the violation of sanction regulations. Because we see in practice that some countries do have criminal sanctions, Belgium, the Netherlands, but other countries still do not have those criminal sanctions. So it is easier, you know, to circumvent or less dangerous to circumvent EU sanctions via a certain country in the EU than via other countries. And then fourthly, there's hard law versus soft law. There was no guidance at all during 10 years that I was practicing sanctions. We had the law and there was very limited guidance, and many of the concepts remained unclear. So when is a company owned or controlled by a sanctioned person, which is an important criteria to know whether you can do business with a sanctioned person. When is a company owned? In the US, it's very clear, 50% shareholdership. In Europe, it was not really clear. Owned was not defined. And so there is guidance, and that guidance is not always the same. So there was guidance that said, okay, it's 50%. And there was other guidance that said it's at least 50%. So what is the result? Owned, what does it mean? There's no definition. Controlled, what does it mean? There's no definition of control. It's the guidance says a dominant influence. What is a dominant influence? That's not a legal concept here. So those are challenges that remain. There is a lot of guidance now, but the challenges often remain. And so that leads me to the final conclusion, because I'm out of time. These evolutions, Russia sanctions, COVID, China, those have made that there is an increased focus on the economic security policy of the European Union. The European Union has always been a favor or in favor of global trade, multilateral trade. All the economies were very open. Belgium, Netherlands, those are economies that go well, thanks to the fact that they are open economies, that everyone can invest. But what we have seen in recent years, since COVID, since the Russia sanctions, is that the openness of the economies are reducing. New measures are coming in, often under pressure or suggestion of the US. Almost all EU countries now have foreign direct investment screening. You cannot invest in the EU without a license if you're investing in critical technologies or in energy or in biotech, for example. So there is the ban on forced labor, which will probably enter into force as well end of June in Europe. And why? Well, because there is this interest in ECG and this focus on ECG requirements, obviously, but also because thanks to the US ban on forced labor, a lot of the goods which are manufactured with forced labor end up in Europe, the second most lucrative market after the US. And all kind of legislation is being imposed and leads to the situation whereby you can no longer trade without doing serious and significant due diligence. And I think that's the main message that I wanted to bring on the EU back on. And I went over time.
We'll have to sanction you.
Yes.
Thank you. Okay, and now, please, Vladimir, give us your point of view, the Russian one, and floor is yours.
Thank you very much. It is my pleasure to take floor here. Adhere to all was said before me, because I especially admired the presentation made by the banker, by the compliance. I can tell you that what he told you is the truth. We in Russia see that what he says is actually the truth, because we have to deal with it somehow. Therefore, I will say a few words how we Russians try to mitigate the effect of these sanctions. There are many regulations in Russia that were issued after the start of the special operation in 2022. These regulations were introduced by presidential executive orders. At the same time, during the last 20, almost 30 years, Russia has been trying to make its legal system fully compliant with the European legal system. Therefore, as a result of this, we have a discrepancy between the legal system and the executive orders. The executive orders of president establish what we can do in the international trade and what we cannot do in the international trade. I can tell you that the presidential orders have significantly restricted capital transactions with currency. Capital transactions. Capital transactions means capital investments. Therefore, we see that from the Russian perspective, a number of banned transactions have appeared according to the presidential executive orders. It is banned to provide loans to non-residents in foreign currency. It is banned to do certain transactions in excess of the threshold established by the Central Bank of Russia in terms of the current trade. Current trade, let me make a short explanation. There are capital transactions which are related to the movement of capital, investment. And there are current transactions, which is payment for goods, services, and intellectual property. There are no restrictions other than the threshold that I mentioned for the current transactions in Russia. The government, the president, allows all these transactions. But the bans are aimed to prevent the outflow of the capital from Russia. It is also banned to foreigners to purchase Russian currency on the Russian domestic, to make exchange operations on the Russian domestic market, because the exchange rate is so significantly fluctuate lately that allowing foreigners to trade with Russian currency on the Russian domestic market would absolutely lead to the outflow of the capital from Russia. And the third point on the final point on this slide is it is illegal to receive dividends in foreign currency to a foreign account. What dividends? The dividends from the Russian companies. It is not legal because but when I say it is not legal, I mean it is against the presidential decrees. And all the banned transactions that I mentioned here can be still implemented by a special permit issued either by the governmental commission or by the Ministry of Finance or by the Central Bank of Russia. These are three authorities who can permit you to make these operations. Why it is important? It is important because many companies, foreign companies, who have invested to Russia now want to de-invest from Russia and exit Russia. The exit isn't easy. You have to go through you have to receive an authorization from the governmental commission. The procedure of obtaining the authorization is public, but there are no procedural rules. Therefore, average waiting time to receive the permit is about 3 to 4 months, if you're lucky enough. Okay. For foreigners, okay, there's another restriction are the special procedures that are established in Russia. These special procedures have the same goal to prevent outflow of the capital from Russia. Probably have heard, if you are related to somehow to doing business in Russia, probably have heard about the account C. Account C is the account to which the dividends from the Russian companies can be paid to. And this account is in rubles. The presidential decree allows payment of dividends in the amount not exceeding 100,000 dollars, if you count in dollars, per month. 10 million rubles, roughly. It is exactly 10 million rubles per month without a special authorization. If you don't have the special authorization, you have to pay the dividends to this account C. And that account C is established without the consent of the beneficiary of the dividends. It is established in Russia by the Russian company in favor of the foreign owner of the dividends. There are special accounts E and D. These are Russian letters, E and D, for payment of dividends on euro bonds. You see, Russia has obligations on euro bonds, but Russia may not make payments for euro bonds directly to the foreign accounts. They simply do not accept. Therefore, the solution was to establish these accounts and make payments there. Account Z or Z or 3, it looks like 3, but this is Russian, Russian letter Z, 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 in any currency for export of Russian agricultural products. Russian agricultural products. Probably you know that Russia has become #1 in the international trade of wheat, the grain. And there is an export duty on wheat. But in order to be actually paid for the goods, we have the Russian president established, the Russian government, the governors of Russia established the possibility of this account. And final account O for the payment for the IP rights, like royalties, etc. The rule is that only 10 million rubles per month are allowed without special permit. And when the amount of royalty is in excess of it, you are free to make payment to that account O. In order to get money from that account O, you need to get, the applicant needs to get a special permit from the Minister of Finance. So what we did to facilitate the trade, I would like to mention the previous speeches that were made before me, and I said that I concur with all the statements that these were the facts. So we cannot pay for the goods if the goods appear on the European or American sanction list. And the problem is not at the side of the, not at the side of the recipient of the goods. The problem is at the level of the correspondent banks. The correspondent banks do not let the payments go through to arrive to the beneficiary of the payment. And therefore, we have to find a solution how to make the payment arrive to the account of the supplier of the goods. What we did, and the government of Russia, by the president of Russia and the government of Russia have established special frameworks to do this. For example, it has become legal, the transaction in hard currency, the transaction in foreign currencies between Russian residents are forbidden by the law unless expressly authorized by the same law. But the amount of permitted transactions in hard currency has been extended lately. It has become legal to transfer, to make payments in foreign currency between Russian residents in favor of so-called financial agents. Of course, the law doesn't use this word, but these are the special purpose vehicles that were mentioned today as VA accounts. Virtual accounts, probably. And this has become legal. There used to be requirements to make international transactions through one bank for Russians. You have to go to your bank and then make payments for goods, services only from that bank. But for instance, sanctions change all the time. Therefore, the bank may be sanctioned or excluded from the SWIFT system. Therefore, the government allowed to make use of any banks in Russia. And it's not an offense anymore. It is legal to get paid in hard cash. You see what? It is not legal to export hard cash out of Russia in the amount in excess of $10,000. But it is legal to get paid in hard currency, in hard cash, not in hard currency, but in hard cash, like in the pocket, yeah, or in the wallet, not at the wallet. So when you cannot receive, you're Russian, you cannot receive payment for goods or for services because of the sanctions. In such case, the government gave you the option, get paid in hard cash. It's one of the solutions that we use. If you enter Russia, you have to file a customs, a passenger declaration. You're not required to file the passenger declaration if the amount of hard cash is below $10,000. If the amount is in excess of $10,000 but less than $100,000, you can file the passenger declaration. This is the declaration that we all file sometimes when we have to, when we enter a country. But if the amount is in excess of $100,000, then you have to file a goods declaration to enter. This is what the requirement says. So this is one of the ways how we get paid for the services, goods or IP exported out of Russia, in case there is a ban on export of such goods. Of course, it is probably from your perspective, it's a circumvention. But from the Russian perspective, it is not. Because if you provide services, good or IP, you have to be paid for it. It's natural. It has become legal to offset mutual claims. You see, we used to have a requirement to repatriate currency for goods, services exported out of Russia. And there was a ban to offset mutual claims. For example, I sold goods for 100 something, and I received services for 10 something. Something is currency. I used to be required to receive that 10 and send 100 outside of Russia. Now I can send only 90 because the offset has become permitted. It has become legal to terminate international obligation by a novation. Novation is a new obligation that replaces the previous one, unless it is specifically forbidden by a relevant executive order of the President of Russia. So all this that I mentioned created a legal framework to do the following. First, get paid in hard cash, make use of financial agents. We call them also non-banking financial institution. Practically, it looks like you specify instead of the correspondent account of a bank, you specify the correspondent account of that non-banking financial institution. Third, it has become legal to make payment in Russia to a Russian company that offsets mutual claims between itself in Russia and its related company somewhere abroad. So netting is permitted. So as a result, you can see that we have established a certain framework allowing to get paid for the services, allowing to services, goods, and work in order to carry on. And as a final point, I can say, and I can witness, that the Russian economy proved to be sustainable. We are not dying. Everything goes as it used to be in Russia. And I can only be happy with that because I'm Russian, I live in Russia. And what can I say? Life is going on. We shall see what we shall see. But we have to exist. We have to deal with what we have to do. What is regarded as illegal and criminal from Western perspective is not regarded as criminal from the Russian perspective, as illegal or criminal. The sanctions themselves are considered to be incompliant with the WTO rules and international order. This is the official position of Russia, that the sanctions are not legal. And this is what I can say about what the Russian government does in order to carry on, to survive. Thank you very much for your attention.
Well, quite interesting, the three views. And I have some questions, but I want to monopolize the talking. And I'm pretty sure that in the audience, or maybe someone online has any question addressed. I will ask if you can address to the panel in general, not individually, unless you have a specific doubt, in order to make it possible to answer, well, not me, but the ones in here. I would say when every one of you were talking, there was a big cloud saying regulatory, regulatory, regulatory. We're looking like no more trade and customs, but regulatory laws with regulatory attorneys are we getting into. For three of you, what you have said is compliance, regulatory compliance. Yes.
I seem to be kicking off very often the Q&As. I guess my question was a bit timeline-wise in the next couple of months, or specifically this year. We're going to have elections in the US. It's very interesting race. Also, very interesting to see octogenarians entering a race. I can't imagine if I'm around 80 years old still want to do this in my life, but it's impressive. To what extent do you think that the whole sanctions framework might be impacted by this? And I guess a specific question for David as well, if the authority lies with the Customs and Border Patrol, is what I'm interested in is how much of the focus of the CBP is on patrolling the border with Mexico rather than goods coming in, for example. So how much of the focus is on one or the other?
I wish I had a crystal ball. With respect to the elections, you're right. The two candidates are making me feel quite young right now. I think who knows? Clearly, Trump's, the nominees are practically set, if not solidly set. At this point, there's still a long way to go, and U.S. politics can be pretty fascinating and how things can turn around very quickly. We've got a number of potential trials and decisions coming down from courts with respect to Trump. Biden has had his share of challenges, both him personally and his administration. It's going to be really close when you think about the way that the Electoral College is set up, and you go by state. And even though we have to look at who wins that election in that particular state for purposes of our Electoral College, right now it's a toss-up. And there are strengths and weaknesses on both sides. I still think at the end of the day, it's really a toss-up. I think Biden might have the edge at the end, depending on how the trials and the tribulations of Trump's cases proceed through the courts. He has a hardcore, solid base. But again, when you look at the registered Democrats and Republicans, I think that hardcore base is maybe 35% of the US. Obviously, they're more than the quote MAGA folks in his camp. But then you also have a number of Republicans who are very anti-Trump. And then there's the independents out there. So I'm not answering your question because I don't have the answer. As far as, and very quickly, I know we're running out of time, how CBP will be enforcing the tariffs and the sanctions moving forward in either administration. I think one indication, when you think about the Uyghur Forced Labor Prevention Act and the anti-China sentiment in the US, the UFLPA passed the Senate with 99 votes, and there are only 100 senators. So if there's any bipartisan issue, I think China is one. Russia, again, there's certainly a majority that are very anti-Russia in the Senate, certainly, and perhaps in the House. So I don't see those restrictions going away, but there's very much an inward focus in the US. So I think protecting domestic industries is going to be very strong.
Thank you, David. Any other question from the audience? If not, I'm going to have one for the panel in general, but to Vladimir in particular. Yeah, the cryptocurrency. I have heard, one of the financial gurus predicted that they're going to go down by the end of the year because government don't like having a currency that they have no control. We passed from the gold pattern to the dollar pattern to now cryptocurrency looks like governments cannot manipulate it as they cannot use the cryptocurrency machine on. Do you think that it may be linked those threats or those predictions of cryptocurrency going down and disappearing as a way to cut, if you may, more to suffocate the Russian possibly the Russian economy and the Russian payments?
Thank you. Thank you very much indeed for this question. This is one of the tools that Russia uses to make payment, use of the cryptocurrencies. But there are issues related to the cryptocurrencies. First of all, I mentioned today that it took Russia 30 years to bring its legal system in line with the European regulations. So from one point of view, we are compliant. From the other point of view, sanctions point of view, we are not compliant. By saying we, I mean Russia. And from the compliance point of view, making use of cryptocurrency itself is regarded as a suspicious operation. You will try, if a company tries to buy cryptocurrency in Russia, the Russian company has to provide a lot of underlying documentation confirming the purpose of the purchase of the cryptocurrency. And as a result, the entry to the cryptocurrency market for legal entities is very difficult. But once you are there are no restrictions. First. Second, cryptocurrency is not regarded in Russia as a legal tender. It is not a legal tender. It is regarded as an asset. Nobody forbids you to exchange one asset against another asset. In fact, you make use of the cryptocurrency as the payment tool, legal tender. On the other hand, you simply exchange between one asset to another asset. In the jurisdiction where cryptocurrencies are regarded as a legal tender, you don't have issues on the other side. In those jurisdictions where cryptocurrencies are not regarded as such, you have the same issue as we have in Russia. Third point. When, for example, you pay in cryptocurrency, in USDT, for example, in USDT for goods, and you make use of the network of Bitcoin. Oh no, Ethereum, of course, Ethereum. Bitcoin doesn't work, they charge heavy commissions, and they are slow. Ethereum is better. You make payment, but the goods are not received in Russia. What do? You have to receive your cash back from the cryptocurrency. And receiving cash back from the cryptocurrency is regarded officially in Russia as a suspicious transactions. So you will have to go for another round of explanations to your bank. You face the potential sanctions of your account and bank being suspended for a while, and one cannot challenge that decision of the bank. You may not apply to the court and ask the court to lift the ban on your operation of the account. This is the way it is done. But if you I've seen such cases when people try to overcome the ban on operations imposed by the bank. And the bank has the right to ban your banking transactions as soon as you received only 1 ruble from a cryptocurrency account to your account. So there are issues of using cryptocurrency in international trade. But if the attitude of the government towards cryptocurrency changes, the cryptocurrency payment for goods in international trade could be a good solution because all the transactions in cryptocurrency are transparent and accountable for. So you know what you did. You have trace of everything you do with the cryptocurrency. Therefore, my answer is, if the government changes its mind, then it will be the solution. And as a member of the working group on facilitation of the cryptocurrency in Russia, yeah, we tried. We got the support from the government, but we didn't get the support of the central bank. The central bank strictly opposes to this because of what you said. The government doesn't control. The central bank doesn't control it. So we shall see. Currently, the government is rather for it, the government of Russia, but the central bank is rather against. That's it. Thank you.
Okay, I think this panel is done. Thanks for your attention, and I hope it fits your expectations. At least mine are totally fulfilled. Thank you, speakers. You're very good.
I think there's still conversations going on around the coffee machine. And a couple of people, we're taking the GLCA members to the desert this evening. So some of them might have gone to change for something a bit more comfortable. It's a pleasure to introduce Rani. Rani is from a company called WebFontaine. WebFontaine, Rani and I spoke a couple of months ago on one of the projects that they are doing. I think the very interesting angle of WebFontaine is, if you look at the members of the association or yourselves working in-house, we're a bit more offline, let's say. We are the techies looking into the laws and regulations. And Rani, probably it's an oversimplification, but is there to help the governments implement, especially in this region, but also in Africa. So very pleased to have you, and thank you very much, Rani, for taking the time.
Hello, good afternoon, everyone. I'm pleased to be here. And yes, I represent WebFontaine Group. I'm in charge of the Middle East, North Africa, Eastern Europe, and Pakistan and the company. And today we're gonna speak about, just briefly about the company and about blockchain and one of our solutions that helps governments, mainly the custom authorities, but as well as all the government agencies involved in trade, mainly in export, import, and transit. So let me start by just going through briefly the company. So WebFontaine Group has been established more than 20 years ago. And basically our mission is to help governments in order to modernize and digitize their customs procedures and processes by introducing systems and technologies and exchange of information in a simplified manner. So our solutions include full customs management or declaration management systems, single window systems, basically for foreign trade, for example, which connects all the stakeholders together. So we simplify and digitize all the processes related to import, licenses, certifications, permits. We connect with the banks, with all the stakeholders involved in trade. So that's what we have been doing for the last 20 plus years. So we have grown to 1,000 employees. We have around 25 projects now, and it's growing mainly in Africa. We have a lot of projects in the Middle East, including the GCC, in Asia, as well as in Latin America. Latin America, we have 2 projects in Panama and now Costa Rica. We're putting there the customs management system. Here in the GCC, we work in the United Arab Emirates, couple of Emirates here, like we worked in Abu Dhabi. We're now implementing the customs management system, replacing the one that exists in Sharjah. We did the same in Ajman, and in Bahrain as well, and other countries in the Middle East region, like Jordan, for example. We've also helped the Jordanian customs in order to improve on the current systems and the inherent technologies around customs and trade that they have. So all our solutions are developed in-house through our research and development centers. So this gives us the agility, scalability, and flexibility, of course, when it comes to working with our partners in the different countries by having very modular solutions which are based on open source and that are easily integratable with other legacy systems that are in the country or in the region. So we put a lot of emphasis into this, and we are considered the largest company when it comes to research and development in the arena of customs modernization and trade facilitation. So we go now to the presentation here, or what I'm going to talk about. Basically, it's about the blockchain and how blockchain helps in order to simplify the trade processes and to secure them, and to ensure governance and transparency along all the stakeholders in the supply chain, as well as one of our systems, which is now growing, not our system, but a system that we have developed based on the recommendation of the World Customs Organization and even the World Trade Organization, which is called the Advanced Cargo Information System. So these two systems go hand in hand, and they are very important for several reasons. As we can see here, as far as these systems are concerned, the blockchain is not a system. We use the public blockchain to support the exchange of information and documents in a secure way so that we can simplify it and we can reduce the cost of trade. For your information, without having these kind of systems in place, the cost of documentation and processes and communication can be up to 15 to 20% from the cost of transportation, the cost of shipping and transportation. This is because of all the complications that are involved in preparing the documents and the communication. So, for example, legalization and certification is a costly and timely and time-consuming exercise to get the documents, like the invoice, the certificate of origin. So by using the blockchain, which is secured, using a distributed and immutable ledger, then this becomes secured fast, and there is the auditing capabilities and the governance so that it cannot be tampered with, let's say. So how does the advanced cargo information and these type of solutions with the blockchain help the different stakeholders, including the government, as well as the private sector? So one of them is about making more informed decisions, knowing in advance what are the requirements, and to use the technology and the system in order to fulfill these requirements without having second guesses and going back and forth. So everything becomes clear on what needs to be done, and everything is done electronically through single sign-on without having to do it multiple times, and it's all digital, of course. And then the risk management here is very important, because using the artificial intelligence, we have a risk management tool in these solutions that helps the customs authorities, but also the other government agencies involved in the trade in order to manage the risks and to detect fraud. So blockchain is a tool, but it's not it doesn't deliver let's say, the benefits by itself. We use the blockchain in order to exchange information and exchange documents without having to go through certification and legalization. And we're seeing this in different countries where through the blockchain and through these systems, they're getting rid of the certification, the notarization, all of these elements that take time, and as I said, are quite costly. And then it lets the trade focus on its core business rather than having to worry about, the manual exchange of information and going to different agencies and authorities to stamp and sign documents. Everything becomes digital through the platform. And the governance is very important here because the transparency, everything is transparent. There is user management. So if there is, any issue, you can go back and see who did what and go back to the history. We know that in customs, now they're focusing on post-clearance audit or trying as much as possible to facilitate the clearance of goods. And then, sometimes if you don't have the full history of the transaction, it becomes very challenging for the customs to trace back what has happened and who is to be blamed. So this is very important here. So going back to the advanced cargo information, basically this is a system that we use mainly in developing countries where there is, they don't have, let's say, strong governance or strong systems in place. It helps mainly the customs authority and even the government agencies like the ministries and those that are involved in issuing, as I said, permits or certificates or approvals or quotas, in order to basically manage the flow of cargo coming into the country by registering the exporters. This is how, this is very important here, the vetting and the KYC of the exporters and the registration and the approval of the importers. So we link the exporters with the importers in the system where the exporter, we do a background check on them to ensure that these are legitimate exporters and that they have proper bank account, which is linked to their commercial registration, for example. So we ask them to make a payment to register to tie everything together, and we do a background check on them. So then they get registered in the system. And also for the importers, they also have to register in the system. Basically, they should also have let's say, the registration details in the system. And that, if there are agencies involved or anything of that sort, it also will be reflected in the system so that the whole trade transaction is proper and there will be no issues when the cargo arrives into the country. So it also serves as a kind of a pre-declaration, let's say, assessment, so that when the cargo comes, there's no congestion at the ports, there are no delays. We ensure here for the vast majority of goods and consignments coming into the country that they flow in without having any issues or last-minute problems. So everything is done in real time. Payments are done electronically through credit cards, through mobile money or wallets or bank transfers through the system. Another important factor here is that data is very important. So all the data is captured, and using business analytics and intelligence, we are able through the system to provide all types of reports and dashboards about the trade, from where it's coming, in terms of value, in terms of volume, the trends, and then, the forecasting, and all of that is done also through the system. And since we are present in many countries, the system supports multiple languages, including French, Spanish, English, Arabic, etc. And that's easy to also translate it into other languages. So it's a very intuitive tool, this advanced cargo information using the blockchain to deliver all these benefits. So here, I'm just going to go a bit more detailed about the advanced cargo information and what it includes. So, as I said, it's an online tool. It manages all the workflows in terms of the import, as we will see, into the country mainly, but it also can also support the export. But most countries, let's say in the region, are more, let's say, when it comes to controls, it's more about the imports. Because exports, basically, there are export promotion agencies and there are fewer controls when it comes to exports. But the imports is where most of the issues and challenges are. So one of the key components here or modules is, the trade information portal, which includes all the information, the workflows, the processes, the requirements, simulation. So this is available for the public before any trade transaction takes place. You go into that trade information portal, you can find all the information, all the regulations, the news, the announcements. And on top of it, what's very important here is this tool helps with the classification. So using artificial intelligence, the trader can, or the exporter can, put the description of goods or use the barcode or the brand or the part number, and then it will translate it to the classification. And then it's auto-classified in the advanced cargo information application. And the same can be then transferred to the customs declaration, because lots of problems happen there in the classification. And sometimes there is a lot of manipulation in order to reduce the custom duty and the taxes by misclassifying goods. So there is strong control here with the risk management tool in order to avoid this type of manipulation. So also an important element here when it comes to risk is to verify the documents. So it's not only the blockchain, but it's also artificial intelligence, where we check into the documents to see if there is the risk of fraudulent documents when it comes to the invoice. So we have millions of transactions. So let's say we know the supplier, the type of invoice, how these invoices are generated, and if there is a fraudulent invoice, then the system detects it, or it alerts that there is a high possibility of fraud in a specific document. So that's another element here that's part of the comprehensive risk management. And when we talk here about risk management, it's not only the customs risk, it's also all the agencies and ministries that basically, as I mentioned, that are involved in trades, those that issue licenses or permits or certificates. And another element here is the integration with the central bank in many countries, because here there are a lot of countries where there are issues with foreign currency or forex. So, and many countries rely mainly on letters of credit. So this is where many problems happen by basically applying for letters of credit and then manipulate that by basically trying to get money out of the country by, playing around, or there are many other, problems there. So we link the letters of credit for the trade in the system itself. In many countries, I'm talking here more in Africa, not in the Middle East region, we don't have this issue. So we've spoken about blockchain and its benefit. So this is just a recap of why we use the blockchain here in this case, because there are many stakeholders, because the documents and the information is shared with many parties. So any party trying to change any document, it will be known what they did, when they did it, and it cannot, it cannot go unnoticed. So here, this is very important. And also everything is digital. There is no need anymore to exchange physical documents. In many countries, there are even laws in this regard where they say, okay, we will accept the digital documents and the digital signature without having to submit and courier legalized and certified documents. So this is a big improvement that reduces time, and lots of cost savings go around this. So this is a brief about the advanced cargo information process. As I mentioned, this is something now that is being heavily promoted by the World Customs Organization. It also helps countries in implementing the trade facilitation agreement. So not all countries, of course, have this, but there's a growing number of countries, mainly in developing countries in Africa and Latin America and even in Asia, are adopting this. The USA has an advanced cargo information system. You cannot ship any goods to the US without registering and getting approval in order to ship, the preliminary approval. So it's the same process, but of course, it depends also on the laws and the regulations in the country. So this is a highly customizable tool. We take into consideration the requirements and the regulations in the country, and we implement it accordingly. So here we see also the different stakeholders that are involved in the advanced cargo information and the blockchain. It's mainly all the parties involved in the trade, including the banks, the exporters, the importers, even the shipping lines are connected to this, or the carriers, because they are an integral part of this in order to secure the supply chain and the movement of goods in a legitimate manner. Now, of course, this reduces fraud, it reduces illegitimate trade. It doesn't prevent it 100%. There are lots of ways, but at least it provides a very strong tool, and it makes it more difficult, much more difficult for goods to be smuggled in or to be tampered with, because everything is clear, everything is managed through the system. Of course, this is as good as the enforcement is good, because in certain countries, the enforcement is weak. So you have a strong system, but then the enforcement in the ports or at the land borders is not up to the standard, and this is where we face challenges. So finally, I'll just recap about Webfontaine Group. We're an independent private company. We work with different governments. We work in different countries. We're completely impartial, and our solutions are highly customizable and modular. And we use the latest technologies based on open source. One of our advantages is that our solutions are based on unlimited perpetual licenses. So we don't have the model of having to pay yearly for licenses. We also transfer the source code of our solutions to the government entities that buy our solutions. And we have a big team of customs experts in the customs domain and in the trade facilitation domain. So although we're a technology company, but we focus on the domain expertise, and this is accumulated through the history of what we've done and the experts who are coming from different fields in these areas on top of technology. So with this, I would like to thank you. And if you have any questions, I'd be more than pleased to answer them.
Thank you, Ryan, for the presentation. This is my favorite part. Webfontaine is a well-known company, and your solution is one of the best solutions, actually. But my question is regarding the perspective of the compliance. Do you have any module regarding the compliance of the companies? So any company would like to submit their declaration, the system will be able to tell them that there may be a mistake or error here and there. And usually those solutions or modules are integrated to the ERP solutions within the company, which is the procurement, the financial. So if you do not have this on the ground, you have the intent to implement this in the future. And where do you think that we are going from the perspective of artificial intelligence in the customs domain, in the digital customs domain? For example, in the authorized economic operator, do you think that we will reach at stage that the machine will do the validation, generate the report, will check the eligibility of the companies. Thank you.
Thank you very much for this two-part question. I will start with the latter part. Basically, yes, this is the future. I mean, we see this trend of full automation and using multiple sources with enhanced machines that will be able to connect all the dots and be able to fully digitize the process. Of course, now using generative AI as well in order to take it to the next level. So this is the trend. Many of those components and what you have about going to fully digital customs, the components are there. Still, I mean, the confidence level is being built up, and the technology, of course, is moving fast. So maybe in the next 2 to 3 years, we will be close to that level. On the first part, yes, on the compliance, yeah, because we incorporate the workflows and the rules and all of that into the system. So if there is anything that is non-compliant that the trader is trying to do, the system will correct and will prompt the company to rectify what they're trying to do if it's non-compliant with the, let's say, not only with the customs but with the whole ecosystem, because it's a very big ecosystem. And then, of course, one of the modules that we have is a legal module also. So if there is any breach or any problem, then that module, that is legal module, will basically tell the customs electronically what went wrong, and it will basically prepare the case, the legal case for that problem. And this could be post-clearance, doesn't have to be, because sometimes there are information that will become available after the clearance takes place. Thank you. Please.
Is Webfontaine participating in the current pilot program for implementation of blockchain of Dubai customs?
Implementation of what, sorry?
Yeah.
Of Dubai?
Blockchain technology in the case in the onboarding and inwarding.
You mean in Dubai itself?
Yes.
No. Dubai Customs, they do have an IT company, an IT arm, and mainly all the development work and the solutions are developed in-house. They have a lot of capabilities, Dubai Customs. They work, of course, with consultants, but neither us nor our, the companies that are in the same field or our competitors are developing any solutions, whether in blockchain or other solutions for Dubai Customs, up to my knowledge. So we're not doing any work in Dubai Customs, frankly, but in other Emirates. And Dubai, Customs is also part of a very big organization which involves DP World, it involves the free zones and the customs. It's all under the same umbrella. And DP World, it also is very integrated with Dubai Customs, with all the systems. So they have a very good IT infrastructure and ecosystem here. And they're trying even to export it and trying to basically, find other opportunities outside of Dubai in order to basically implement the customs management system, for example, which is called Mersal 2, as part of their, expansion and the projects that they are gaining outside of the country.
Dubai Customs is promoting this pilot program for implementing this technology on the different customs processes. So I think that there is going to be a deployment of this at least of this technology for some package operators, and these and all these actions are promoted by customs.
Definitely. Thank you.
Thank you, Ronnie. Just in the interest of time, I'd like to thank you as well. I'm gonna have a gift for you as well.
Thank you so
very
much.
much for taking the time.
Thank you.
Trying to locate the next speaker, but I think he might be outside. Let me check. Stop. This is Mustafa. Please have a seat, Mustafa. Come up to the stage. You can come and sit next to me. For a last bit, before we wrap up in 25 minutes or so, we have Mustafa here from Evotech. He's going to be introducing the company in a bit. Also brought a video. So the format of this bit is going to be slightly different. Sound, please. Is this working still? I think so, yeah. Can we get a second mic, perhaps? Yep, thank you. Mustafa?
Thank you, Thomas. Can you hear me?
Yes, we can. Please go ahead and introduce yourself. I have the 6 vetted questions as well, which I'm going to ask you in a bit, but good to see you. Can you introduce yourself and perhaps Evotech as well?
My name is Mustafa Habib. I'm the functional lead at Evotech. We're really excited to be here to talk about Smart Track solution and Tatmeen program.
Very good. So you're mentioning Tatmeen already. Tatmeen is a project being run for the Ministry of Health, evolving around safety and security. Could you tell us a bit more about this project and how Evotech got involved in it?
So Tatmeen is a nationwide program in UAE that has enabled traceability of pharmaceuticals using serialization with GS1 standards. Tatmeen is a flagship program of Ministry of Health, part of phase 1, 7,500 conventional and biological medicines, and around 15,000 locations in the UAE supply chain are part of scope. Already 80 million saleable items have been tracked through Tatmeen since the go live in December of 2022.
Okay. And so how does the, I guess, number one is what is the objective of the Ministry of Health and the authorities, and how do you track those items and what technology do you use?
So Evotech Smart Track technology, which is highly scalable and has the ability to handle large data sets, is used to track items in the supply chain. It allows tracking of the items going forward in the supply chain and tracing the history backwards to understand the history of the transfers in the supply chain. Smart Track, in addition to Tatmeen, can be utilized in other sectors like auto parts, animal medications, beverages, soft drinks, luxury items, consumer products. In order to enable traceability of the items, items must be serialized with globally unique serial numbers and barcodes. So those need to be imprinted on saleable units as well as logistics units. So products can be uniquely identified by GTINs, global trade item numbers, based on GS1 standards. So if we take a box of Panadol Extra with certain attributes, like strength of 500 mg, 50 tablets in a box, this can be uniquely identified by a GTIN. A saleable unit of this particular product, Panadol Extra, is
this will be uniquely identified by globally unique serial numbers, also known as SGTINs. And those sellable units are going to have barcodes based on GS1 standards, the 2D data matrix barcodes. The logistics units in the supply chain, they are identified by something called SSCC, serial shipping indicator codes, and they are barcoded with GS1 1.8 linear barcodes. And for tracking, each location needs to be identified in the supply chain also, and they are identified by global location numbers, which has also they have partner master record, which has the attributes like geocoordinates of the location, the name of the location, the address of the location.
And the main purpose of the Ministry of Health was safety and security of the tracking the origin of the medication, pharmaceutical products. Is that right?
So the Evertech Smart Track technology ensures the safety and security of the supply chain. Now, the main benefit is reduction of counterfeits and parallel imports. The other use cases are inventory visibility throughout the supply chain, strategic stock management and planning, to have predictions of basically the shipments coming in, and what are going to be the consumptions going forward, any stock out situations that can happen in the supply chain, and take the necessary action. Also, there can be min and max defined for these strategic stocks to send out alerts, if the min and max are breached. The batch and product recall at a faster pace. So the items which are under recall, SmartTrack knows where these items are located in the supply chain, the exact geolocation of those. And alerts can be sent out to the partners in possession of these stocks to take the necessary action to complete the recall. Moreover, have a better visibility of expired and expiring stocks in the supply chain. So necessary action can be taken to avoid any expirations in the supply chain.
Very good. You want me to play a video, I believe. Is that right?
Yes, yes,
yes. Thank you for preparing that for us. He's moving the slides as well. There you go. Is it supposed to have sound or not?
No, this is just an animation.
Okay.
So basically, we're going to talk about the process. So that's the reason why we wanted to have this video here, this animation here. Yeah. So, yeah, so I'll talk about the process then. Sure. So the tracking starts with the commissioning process, where the product owners, the manufacturers and the distributors, they share the serial number and they report the serial number of these items with the SmartTrack solution. So in turn, SmartTrack knows now that these items are coming from a known source and these are authentic items. Following the commissioning process, anything which happens to these items in the supply chain must be reported to SmartTrack. After commissioning, aggregation process builds the physical and electronic hierarchy of the serial numbers of different levels. For example, saleable unit is packed into a logistics unit like a bundle, and bundles can be packed into a shipper case. Shipper cases can then be packed into pallets. So throughout the supply chain, the users and the supply chain partners only need to scan the top logistics unit, and SmartTrack already knows what is packed inside. Following the aggregation, the stock can be transferred to the supply chain partner who is responsible for the customs process. The customs inspectors then go through import clearance and shipment release processes for the imported items, following which the market release process is executed for both imported and locally manufactured items. After this, the products are free to move in the supply chain till the time basically they reach the point of sale where these items are sold and dispensed to the customers. And that's where the tracking stops. So these get decommissioned from tracking point of view. The tracking life cycle stops there. So, you know, in addition to this, you know, basically the product, the way the product goes, it has different statuses in the supply chain. Some are temporary, some are permanent. Temporary statuses are blocked, unblocked. Permanent are where the permanent statuses are not reversible, which decommissions the products basically. So, you know, things like product is damaged, lost, stolen, dispensed, we already talked about, exported, expired. And throughout the supply chain, the users, supply chain users and the government entities, their users can validate these items by using product verification processes. And, you know, this, the government users also can see the whole journey of these items going from commissioning all the way to dispensation. Moreover, you know, SmartTrack provides 3 different mediums to execute these processes. And, you know, so we have mobile apps, portal, and B2B connectivity, system to system connectivity using APIs, application programming interfaces.
And to be clear, all of this is done without adding any hardware to pharmaceutical products.
So exactly. So, you know, there are some big pharmaceutical companies, you know, they would like to share the data directly, report this data directly to SmartTrack from their own systems to SmartTrack, doing the B2B integration. So APIs, the application programming interfaces are exposed by SmartTrack, where they can connect and share the information. But for the smaller supply chain partners, they can connect through either mobile, they can use either the mobile app or portal to execute every single business process, where everything is there in all these 3 mediums.
So if we go outside right now, we have a pharmacy outside over here. Pharmacy might have stock. Your system knows perfectly how much stock, which product, how long it's been there, what the status is of that stock. Is that correct?
That is correct. So every single product, like I said, has a serial number, and they can be uniquely identified which particular pharmacy it is located at, what is the expiration, is it going to expire in the next 90 days, whatever happens to that stock, whether this is packed inside a logistics unit, you know, it can be seen by the relevant authorities. Basically, not everybody has access because, you know, only the pharmacy themselves, they can see it, and then the government authorities can see all this information.
So the use cases in the healthcare sector in the UAE, but you mentioned as well, there's nothing preventing other sectors from using the application as well. So what's the other kind of use case that you would typically see for this, where you'd see this very beneficial? I think you mentioned car parts before. Any other sectors where you would see benefit?
Yeah, so auto parts is one, halal foods is also one, consumer products, luxury items, animal products and medications, soft drinks. So anything which needs to be tracked. I mean, you know, like I said, the main benefit is a reduction in counterfeits, right? So in the supply chain, you cannot have 2 products dispensed, right? Like I said, the item has a life cycle, tracking life cycle. So if a counterfeit is introduced in the supply chain, alerts are generated and they can be shared directly. If somebody is trying to have even copy the serial number, have another barcode imprinted on the counterfeit product, that can be caught right.
Okay. And is there anything that you can share around the effects of this since it was introduced a couple of years ago in terms of reduction in counterfeit?
So from the use cases from the benefits point of view, I mean, this has been a little more than 1 year. Like I said, 80 million Madisons are already being tracked. One of the thing which we experience is basically when you're talking about the whole supply chain, and we talked about like from Tatmeen point of view, it was 15,000 locations. So having them all onboarded is a very complex process, right? So when everybody is onboarded, then tracking works properly. But just from experience point of view, anytime there is suspect activity in the supply chain, the government agents do get notified. And these alerts are sent out, notifying them that there's just some suspicious activity. Obviously, it's not like, it's a suspicious activity alert where more investigation needs to take place, where somebody from from the government departments need to go out there and inspect what is going on.
And I suppose that suspicious activity is based on a certain type of analytics. So it'd be interesting a bit to hear what analytics you have, and maybe, I don't know, out of personal interest as well, what would be a trigger for suspicious activity? Is it a large increase in stock all of a sudden, for example, compared to normal stock or?
Yeah, sure. So from analytics point of view, there are a wide range of analytics which are available to users, starting from commissioning dashboards and reports, which basically shows the new items that are commissioned and reported to SmartTrack during a certain time period. Then you have the product transfers, which basically show the shipping and receiving in the supply chain. In-transit stock reports, which talk about the items that are in transit, and also it talks about the duration of these items for which they are in transit for. Because if something is in transit for more than a certain period, then needs to be investigated to understand why. Then the customs dashboards and reports, which shows the items that are available for customs release and the items that got custom released. Strategic stock management, planning, and management and planning dashboards, which shows the strategic stocks. And like I talked about, this basically shows the predictive analytics, and we can define min-max for these stocks also. And then you have the expiration and expired stocks dashboards, and dashboards which basically show the batch recall, product recall, and then different statuses of the products. From the suspicious activities and alerts point of view, the way it works is in the supply chain, anytime there's a suspicious activity because there's a life cycle, right? So the items are going through commissioning all the way to dispensation. So now in the supply chain, for example, like UAE, somebody is trying to introduce another product, and so, and trying to scan it because the items are being tracked, right? So now this item is being scanned in different location. Even with the same serial number, alert will be generated. If somebody is trying to do multiple dispensation of a product, alerts will be raised, right? So even the system is not going to allow it, because like I said, you can only dispense once, right? After that, the tracking stops. And if you try to dispense it again, system is not going to allow. But at the same time, alerts are also generated with the geolocations of where these things are happening.
Okay, very interesting. Perhaps open it up to the audience as well. I think, Katarina, you were mentioning to me that you worked quite a bit on parallel imports for pharmaceuticals. I don't know if you want to say a couple of words and maybe have a question as well.
Hello.
Hi.
So in the EU markets, even though it's a unique market, integrated market, there are a number of restrictions when you want to either place medicine outside the national market or inside the national market, what we call parallel import and export. So I would like to know, because you also mentioned parallel import here, I would like to know the views on that here in this region. And from experience, the regulatory entities usually have all this data from the trace systems, which are also in place in the EU market. And sometimes they ban exports or they don't accept imports based on the data, but they don't disclose the data to the companies that operate in the market. So they sometimes are restricted from their activity, but they cannot really defend themselves against what is being told because they don't have the data. So I don't know if it's if it will be the same or if that system is public to all companies here. In the end, it raises a lot of questions in the EU market about free circulation of goods and the restrictions based on data that is being provided to the system, which sometimes it's not all the times accurate. So it's just to share this information.
Sure. Okay, so on the parallel imports, right? So I'll take the example of Tatmeen. So Tatmeen, the way it works is at the time of commissioning in Tatmeen, there is a lot of validation which happens, right? So when I talked about product owners are only allowed to commission these items in Tatmeen. So what that means is, there is a product master record at the back of this particular product, which basically identifies the product owners, the manufacturers, and the distributors. Now, when we talk about parallel imports, so we're talking about an unauthorized distributor trying to bring in these medicines in the supply chain. Here, what that means is doing not only because this is a MOHAB system, right? So not only that it basically goes back in the product master to see, okay, whether this particular supply chain partner is authorized to commission these products, but it also checks against the MOHAB import permit system to make sure that you have a valid import permit for these products, right? So you're going to commission them, and obviously you're going to go take them through the customs process. But not only that, you have the right quantity which you're trying to commission with that thing, right? So with Smart Track. And if you're trying to go over, so it basically raises an alert and it errors out. So, so from parallel import point of view, throughout the world, that is somewhat an issue, because not only the supply chain loses a lot of money, but you see, it might be a legit product in some country and it might not be something which is good for consumption in another country. So it's not a counterfeit per se, but still it's in a gray market, and so that means catches that.
We have time for one more quick question. Ken, would you mind bringing the mic, please?
I just have a quick question. How do you think that your solution may enhance the customs control of the shipments inside the free zones and bonded warehouses, mainly the non-fenced free zones and the bonded warehouses, which is not under customs control? Now there are many free zones in United Arab Emirates, which is not fenced. There is no customs centers or no customs officers are based on those free zones. How do you think that this solution may support customs administration in enhancing and strengthening the control in those areas? Thank you.
A good question. So now, when you are deploying this solution, you have to identify the scope. Where are you going to track these items? So here, I'll take an example of Tatmeen again. So for Tatmeen, the scope was defined, all the products which are coming into mainland UAE. because in the free zone, there's a lot of products which are coming in and, they can be destined to some other countries. Also, a lot of products are being produced inside UAE, but they might be destined to another country, right? So what do you do with those? So from Tatween point of view, like I said, we have to put like a boundary of what we want to track. So what we are tracking is the items which are coming inside UAE mainland and the items which are being produced for the circulation inside, locally produced items for the circulation inside the UAE mainland. Anything which is going out is not tracked. So this is one thing, because the thing is, you have to also imagine, if you try to track an item which is in the free zone, what do you do with this? It goes to Oman now. What do you do with that? Do you build another system there? You can do that, basically. Smart Track will allow you, but then again, what is the scope? Are you just trying to track inside the country or just outside? So, we have to put limits there.
Thank you very much for that question. That seems a very interesting combination with more of a compliance and enforcement program as well. I think we're going to be wrapping up. Thank you so much, everybody, for coming. Thank you for those of you who attended online. I hope you enjoyed this first ever in the Region Customs Conference. So it was quite interesting to hear from different speakers. Thank you, Mustafa, and have a good day to everybody. Thank you very much.
Thank you, Thomas. Thank you.